Welcome back from the tea break. Please let's settle down. The session is about to start. We welcome all of you. And then if you are we still have some ushers in the room. Let's go and get them from the tea place and bring them back here. Our moderator is already set. So without wasting your time, let me hand over to him. He will do the business. I welcome you, sir.
Professionally, politically exposed. They are pointing at each other. Pep. Pep.
Our plan according to the timetable is 4:30, so it shouldn't be, we're running about 30 minutes late now. So if we assume that worst case, fine, likely. Those afternoon sessions are likely to be quite interesting as well. And it depends on how quickly we can get to lunch and get back from lunch. But let's say Right. Good afternoon, my lords, learned senior advocates, distinguished ladies and gentlemen. Welcome back from the tea break. It's 11:30 now, and we're going to start the second segment of today's morning session. This session is going to deal with the topic which really has been foreshadowed by some of the discussions in the first session. The topic is examining various models for professionalizing the administration of the courts whilst ensuring the independence of the judiciary and proposals for constitutional and legislative reform. A lot of what we discussed in the course of the first session, I'm sure you would all agree, raised questions as to whether the way in which our courts have been administered hitherto is optimum or optimal. Obviously, we've had some lucky courts, either at state or federal level, who are lucky enough to be headed by judicial officers who, either by dint of personal development, by dint of talent, have good administrative capabilities. But I think it goes without saying that judges are not part of our training as lawyers. It's lawyers that become judges. Not part of our training to administer complex organizations such as judiciaries can be. So this topic is to examine various ways of addressing this problem. We have a very, very stellar panel to discuss this. We have an expert, a subject matter expert on this matter, Dr. John Sorabji, who is joining us virtually from the UK. And as I said to him, just to establish beyond any peradventure, he's the right fit to be dealing with this. I'm going to read his profile. I'm going to embarrass him by reading his profile in full. Dr. John Sorabji is an associate professor of law at University College London, where he teaches modules on alternative dispute resolution and principles of civil justice. He is also a member of the Civil Justice Council of England and Wales, a statutory non-departmental advisory body that is required to keep the civil justice system under scrutiny. He was previously the Deputy Private Secretary to His Majesty King Charles III, and before that, the Principal Legal Advisor to the Lord Chief Justice of England and Wales and the Master of the Rolls. In both roles, he has provided advice on constitutional issues. He has advised on a wide range of issues concerning judicial governance. He has provided, for instance, scrutiny of the Constitutional Reform Act 2005 and the development, drafting, and critical assessment for the judiciary of the Crime and Courts Act 2013, amongst other legislation concerning the judiciary. Both acts concern the governance of the judiciary. He has also advised the senior judiciary on a range of issues such as high court reform, digitization of the civil justice system, and deployment of the judiciary across the courts and tribunals. Latterly, he was responsible for the creation of the Judicial Data Protection Panel, following the implementation of the General Data Protection Regulation and Data Protection Act 2018. He has experience in drafting legislation for reform reports and for the judiciary as a means to test assumptions in proposed legislation, as well as drafting rules of court and practice directions, not least during the COVID-19 pandemic. He has also been and continues to be a visiting professor at Université Panthéon-Assas, where he lectures on the English civil justice system. He is author of English Civil Justice After Wolfe and Jackson, and a Model Code of Civil Procedure for England and Wales, which is forthcoming 2024. He's a contributing editor and author of Fosket on Compromised Civil Litigation in a Comparative Context, Zuckerman on Civil Procedure, and ELI UNIDRA, Model European Rules of Civil Procedure. He's the general editor of Civil Procedure, the White Book, the leading commentary on the civil procedure rules. He is also a former member of the European Law Institute's Executive Committee and Governing Council. He has also been a governor of the Expert Witness Institute and acted as an expert for the Venice Commission. So, Dr. John Sorabji, you're welcome. He's definitely, I dare say, more than capable of dealing with the topic of today's session. Next to Dr. Sorabji is somebody who needs no introduction, not just because of his towering height, physically, but also, as was said yesterday, because of his towering intellect. Honorable Justice Kashim Zana is Chief Judge of Borno State. He chairs the Judicial Information Technology Policy Committee of the National Judicial Council. He sits on the boards of the Global Judicial Integrity Network, the International Society for the Reform of Criminal Law, the International Institute for Justice Excellence at The Hague, the Judicial Panel of Lawyers Without Borders, the Commonwealth Judicial Education Institute, and the Commonwealth Judicial Education Institute. In October 2023, he was unanimously invited by the Board of Directors to assume the office of the President of the Commonwealth Judicial Education Institute. Of particular relevance to our discussion, the Borno State Judiciary has consistently ranked #1 on the Pace of Justice Index survey results of Citizens Gavel. Vindicating Gavel's ranking, correctional facilities in Borno State have for about 10 years now recorded no congestion, with vacant rooms and awaiting trial inmates of less than 25 to 30%, as against the 60% and above prevalent nationwide. Justice Zana is a recipient of the Medal of the International Society for the Reform of Criminal Law and Distinguished Service Award of the United States National Center for State Courts. Justice Zana, you are welcome, sir.
Yes. The second half of
and last but not least, also a gentleman who requires little introduction to those of us who are in this sector, is Professor Bolaji Owasonye, Senior Advocate of Nigeria, OFR, FCIR, NPOM. Professor Owasonye is the immediate past chairman of the Independent Corrupt Practices and Other Related Offenses Commission, ICPC, and is presently the Taslim Elias Distinguished Professor of Law at the Nigerian Institute of Advanced Legal Studies on sabbatical focusing on illicit financial flows. He's a former Executive Secretary of the Presidential Advisory Committee Against Corruption, PACAC, from 2015 to 2019. He was chairman of the ECOWAS Investment Policy and Code Drafting Committee, 2011 to 2015. The member of the AU Committee on Community Investment Code 2014 to 2015, the member Working Group on Common African Position on Asset Recovery of the African Union High-Level Panel on Illicit Financial Flows, is a member of the UN General Assembly ECOSOC established FACTI panel in 2020 to 21, and he's a member of the Chandler Sessions on Integrity and Corruption at Oxford University Blavatnik School of Government. Professor Owasonye, you're welcome, sir. Now, with this stellar panel, what we intend to do, we asked Dr. Sorabji to do a presentation. He's going to make a presentation sharing his experience on what an ideal administration structure should be for the courts if there is a concern, as there is legitimately, that the administration of the courts should be handled in such a way that the independence of the judiciary is not compromised. And we'll hear a lot of that from, I'm sure, from Justice Zana. Justice Zana and I have had a lot of very heated arguments over the last year or two, over the last 2 years, where I've expressed my concerns about the poor administration of the courts, and he's expressed his concerns about whatever proposals we're making and the impact they would have on the independence of the judiciary. We're trying to find a truce somewhere in the middle, and I'm hoping that we will achieve that truce today. So Dr. Sorabji is going to make his presentation. He has 30 minutes. It's a very detailed presentation. And then we will hear from Justice Zana what he thinks about the views expressed. And we'll also hear from Professor Owasonye. Professor Owasonye also, over the years, he and I have engaged extensively on this topic. And he has his own strong position, which I'm sure he will express about whether funding is the problem or whether it is administration and management that is the problem. So, John, over to you. Your slides, I hope you have the capacity to share your slides, and you have 30 minutes starting now.
Thank you very much. Hopefully you can all hear me. Let me see if I can share my screen. That's always the first challenge of any presentation.
We can hear you.
Excellent, excellent. All right, let's see if we can get the slides showing. They appear to be on screen. Excellent. So thank you very much for inviting me today, which I'm sure is part of what is a very important discussion that you're currently having. And I hope very much that I can help a little with your deliberations. What I'm going to talk about today is reforming, or reforms, I should say, of judicial administration. And I'm going to cover 4 broad areas. First of all, I'm going to look at some general principles. Then I will move on to look at the model of administration of the courts, which is prevalent in the UK. So I will look at the courts and services administration in England and Wales, and then look at the UK Supreme Court's administrative model. I will then turn to talk about some broad themes in respect to models generally of judicial and courts administration, before looking at hopefully some design principles that you may wish to consider. So those are the 4 parts of the presentation. And I think if we turn to general principles, a starting point that I think we can all agree on is that judicial independence is an essential feature of the rule of law. Now, when we look at that in terms of judicial and court administration, one of the things that we need to bear in mind when we look at international standards is that where judicial matters are concerned, so dealing with matters which ought properly to be within the province of the judiciary, so judicial functions, and those I would include by reference to listing cases, case management, decision-making, adjudication. Of course, before you get to that point, the deployment of judges to sit in specific courts, to hear specific cases, and the individual allocation of cases to judges, all judicial functions. Now, from an international standards perspective, those matters ought exclusively to be within the responsibility of the judiciary, as the Mount Scopus standards put it. Although it's interesting to note that those international standards do suggest that there can be joint responsibility in a manner of speaking for those type of judicial functions in a way that is not contrary to judicial independence. And I think from that perspective, just to flesh that out and to give one example, the listing of cases for hearing, I mean, if it were to be in the hands of the executive, that might pose significant problems for both judicial independence and for the rule of law. The executive could, for instance, if it controlled listing, decide when and when not to have cases come on where they were the defendant. So problems if it was in the hands of the executive completely. But where it could be jointly dealt with by the judiciary and the executive might, for instance, be where court officers, court staff are actually carrying out the listing function, but they do so under the authority and under the auspices of the judiciary. So a partnership in that way. So you can have joint responsibility, but very much the civil service or the court staff carrying out those functions do so on behalf of the judiciary. So jointly in that respect. Now, if we just turn to the next slide, we can obviously see in this the importance of institutional independence of the judiciary. So in the example I just gave of listing, where there's cooperation, partnership between court staff carrying out listing functions on behalf of the judiciary, that does not impinge upon institutional independence. In fact, it comes within the scope of it because the judiciary are in control. They're the ones authorizing, etc., the listing process. But when we think about institutional independence more generally, one of the things that we need to bear in mind is that it can refer to 2 separate things. So first of all, what I've been talking about so far, we could describe as adjudicative independence, independence in respect of judicial decision-making, what judges do in respect of ensuring cases are heard and determined according to law. Those would be the judicial matters, as the Mount Scopus principles refer to them. But we can also consider administrative independence. Now, that would refer to aspects of court management which do not relate specifically or predominantly to decision-making or adjudication. So for that, we could include such matters as budget management, as resource planning, as the management of court buildings, the management and administration of court staff, their appointment and their terms and conditions of appointment and service. Equally now, of course, very important, we can talk about the procuring and running of court IT, filing documents, managing court files or e-files as they are increasingly, and also liaising with lawyers and parties. So we can see the court administration, that which deals with non-adjudicative, non-judicial matters. We can see the necessity, arguably, for independence there as well, in order to secure the institutional independence of the judiciary. But one thing we need to bear in mind is that adjudicative and administrative independence do not necessarily run together. You can have one without the other. And the examples that I'm going to turn to in a moment, specifically in England and Wales, demonstrate that there is adjudicative institutional independence, but there isn't administrative independence. We have a model where there is a partnership between the executive and the judiciary in terms of administration. And I will flesh that out in a moment. In the US, and I'm not going to look at this specifically, there is both adjudicative and administrative independence. There's no executive involvement in effectively the management of the federal courts. And one of the things that I will hopefully point out as I go along is that the overall trend worldwide where court administration is concerned, where administrative independence is concerned, is that there is a move towards independence, or at least partnership models of varying degrees between the judiciary and the executive where that is concerned. So there's not an absolute commitment as a global trend to what you could describe as pure administrative independence. So as I turn to the English model particularly in a moment, one of the things that we do need to bear in mind is that where you have partnership models, partnerships in terms of the administration of the courts, that partnership must not undermine adjudicative independence. So there is a clear link between the two. And we need to ensure, in whatever reform you may be considering, that insofar as the executive or other bodies, or however the structure may be, that the structure and the reforms you alight upon do not undermine adjudicative independence. And I'm sure that that's something that you have been debating, and possibly that's what was being alluded to in the introduction. With that in mind, let me turn now specifically to England and Wales. Now, in England and Wales, we've had three different administrative models for running the courts. Up until 1971, we had what is a judicial administrative model. So the judges were in charge of the administration of the courts, just as they were and are still in charge of adjudication. Now, in 1971, we moved away from that position following a reform report called the Benson Report. And the reason why we did was because of the very significant management and administration problems that were evidenced in the courts around the country. Effectively, what we saw was individual judges, senior judges in individual courts, running those courts and running the administration of them, which meant that with a different judge running different courts, you had different and inconsistent approaches across them to administration, which led to inefficiencies in management. It led to delays. It led to differential approaches and timeliness of adjudication. It undermined, as a consequence of that, equality before the law. Also, because you were looking at a localized structure, you were not able to realize, or we were not able to realize, economies of scale in terms of management or procurement, for instance. And in reality, what we saw happening was that the actual day-to-day administration was effectively being devolved to local court managers or administrators who are actually, and in reality, running the courts themselves. So to overcome the problems that were saw running up to 1971, the government decided that it would move to a wholly executive model of administration. So the Lord Chancellor's Department, our Minister of Justice, in terms, took over completely the administration of the courts within England and Wales. That was not met without some resistance. Lord Brown Wilkinson, for instance, a law lord, during that period, described it as unconstitutional for that to have happened, and argued for a significant change and a move back to a more judicially focused model of administration. To a degree, we saw that occur in 2011 when we created what is effectively the current judicial and executive partnership model, which I will detail a little bit more in a moment, which is the model which is operative today. It's described, and you will see it in the literature, described as a partnership model. It is a strange form of partnership because it exists solely at the will of the executive. If the executive chose to abandon it or move back to the executive model, it is entirely within their gift to do so. So it is not a partnership of equals, although it operates in practice as a partnership. There was an attempt in around about 2013 to 2015 to place this partnership model on a legislative footing and to reform exactly how the overall management of it was to take place. That event or attempt to reform came to nothing, though. So we have the current partnership model, which I will now provide you with some details about. Before doing so, there is just some background that needs to be taken into account. So underpinning the partnership between the judiciary and the executive are a number of statutory duties which are imposed on the Lord Chancellor, the Secretary of State for Justice, in respect to the courts and the courts administration. So from 2003, the Lord Chancellor has been under a statutory duty to ensure that the courts are provided with an adequate budget, adequate court buildings and court staff. Of course, accountability in respect of that comes from the Lord Chancellor being accountable to Parliament and, of course, to the public through the possibility of judicial review in respect to the exercise and carrying out of those duties. In 2004, we also saw through an agreement known as the Concordat, which was an agreement between the Lord Chancellor and the Lord Chief Justice, the requirement that the judiciary, for the first time formally, were to become involved in resource planning for the court's administration. So we start to see the judiciary becoming involved more formally within what was an executive model up to that point of courts administration. And in 2005, the Constitutional Reform Act provided statutory duties imposed on the Lord Chancellor, first of all, to uphold the rule of law, and secondly, to support judicial independence. Now, of course, insofar as the Lord Chancellor, the executive, is responsible for the executive side of the partnership, he has to exercise his responsibilities in respect of the administration of the courts consistently with judicial independence. So cannot do anything that would undermine, for instance, adjudicative independence. And finally, ministers generally and civil servants generally, which is important because the court staff are all civil servants, are also required by statutory duty not to interfere with judicial decision making. So again, whatever functions the court staff carry out in terms of the administration under the partnership model, they have to do so in a way that does not harm or impair in any way the effective adjudicatory process. So the management of judicial functions, the exercise of judicial functions, adjudicative independence. So that's by way of background. The partnership is now set out in what's known as the HMCTS Framework Agreement, which has been in place since 2011. The latest version has been in place since 2014, and negotiations were at some recent stage taking place to revise it, but they have so far not yielded anything in public, at least. And that framework puts in place what can best be described as a corporate management structure for the courts and for court administration. The structure is tripartite. At the highest level, the Lord Chief Justice, on behalf of the judiciary, and the Lord Chancellor, on behalf of the executive, are the two principals. They are the ones who are ultimately responsible for the partnership operating, and they are the ones to whom everybody else within the partnership structure and the management structure is responsible too. Underneath the Lord Chief Justice and the Lord Chancellor carrying out the overall day-to-day management is a corporate board, and I'm going to turn to this in the next slide. And then below that, there are administrative and operational management layers. Now, of course, the one point to remember from what I said a moment ago is that because this isn't a statutory partnership, in the event of any disagreement between the principals, the Lord Chancellor, subject to his statutory duties, has the final word. So not necessarily a partnership of equals, but nevertheless, it works well. If we turn to the board structure, the board, as I mentioned a moment ago, sits underneath the Lord Chief Justice, the Lord Chancellor. It reports into them. And it is structured in a way that it has a broad range of expertise upon it. It's chaired by an independent non-executive chair who is always appointed from the private sector. The present chair is Sir Richard Broadbent. He used to be the deputy chairman of Barclays, and before that, he was the chairman of Her Majesty's at the time, Revenue and Customs. He was appointed following an executive search process and because of his business expertise, his expertise in managing large and complex organizations. The board also has on it 3 judges, each of whom are accountable to the Lord Chief Justice for the exercise of their duties on the board. They are currently the senior president of tribunals, who is head of the tribunal service within our overarching courts within England and Wales. Also the senior presiding judge, who has overall operational jurisdiction for the operation of the courts from the judiciary side. And there's also a specialist district judge as well, who has particular expertise in the operational management of the county courts, or county court as it is now. In addition to the judiciary, and you'll see the judiciary are not in the majority, they're very much in the minority on the board, there is a chief executive officer who operates as they would in any large operation and business. They are usually a civil servant, but they are not always a civil servant. Previously, one CEO was appointed from the business sector in around about 2013 to 2015. But generally speaking, civil servants have been appointed. Now, of course, this is a weakness, it could be said, or it might be said by some, because the CEOs, if they're not taken from the private sector, generally, while they have very good experience of operational management of the courts, they possibly do not have as effective management skills in terms of large organizations, such as HMCTS is, the court service. In addition, there are 3 executive directors, chief financial officer, an operations director, a HR director, again, all civil servants, and 3 non-executive directors who are appointed through a public appointments process. And there is 1 civil servant appointed, a senior civil servant appointed to represent effectively the Lord Chancellor and the Ministry of Justice. So it is a broad board structure, which is responsible for the courts. In terms of the chief executive officer, they are ultimately responsible for the day-to-day operations of the courts, and in terms of financial accountability to Parliament for the budget, and they would be expected to appear before parliamentary select committees for questioning in terms of budget as well as operational matters. They're also responsible for the strategy for the court's HMCTS's performance and also its business plan. And as I said, because of their familiarity with operations, it helps in that sense for them to be civil servants. But again, the point, they lack corporate experience. So perhaps better for them to be appointed from outside and to gain the experience of running and operating the court in another way in terms of management. In terms of the HMCTS staff, the court staff, they are all civil servants who owe a statutory duty to the government, but they act while working for HMCTS under a joint responsibility to the Lord Chancellor and the Lord Chief Justice. And that responsibility is set out within the framework agreement, and it requires them to provide high quality, impartial, transparent, and honest advice. And of course, that is subject, of course, to their statutory duty, which I mentioned a moment ago, not to interfere with judicial decision making. So adjudicative independence comes to the fore. In terms of its budget, that is negotiated by the executive internally. So it's the Lord Chancellor negotiates with the Treasury for the budget. Again, that's consistent with the Lord Chancellor's statutory duty. And the Lord Chief Justice, further to the Concordat, has input into that process. So that, in essence, is how the court's administration operates for HMCTS in England and Wales. It's slightly different for the UK Supreme Court. That isn't a court of England and Wales, it's a UK-wide court. So it's not subject to its administration being carried out by HMCTS, by England and Wales's court service. It operates differently. Its administration is solely taken and provided by the court itself. So it is a statutory judicial administrative model, so wholly independent of the executive. It's not a partnership. Again, though, the Lord Chancellor is under a duty to provide it with its budget, its buildings, and those duties are set out in the Constitutional Reform Act. In terms of management, the Constitutional Reform Act provides that management responsibility is a matter for the President of the UK Supreme Court, so for currently Lord Reid. And it also provides that the President is responsible for appointing the Chief Executive Officer, the court officers and court staff. There is no comparable board structure as there is for HMCTS. The 2005 Act specifies that the President of the UK Supreme Court may not delegate any judicial function to the CEO. So it protects, in statute, adjudicative independence in that way. It does, however, provide for the President to delegate all non-judicial functions, so all the administrative functions, to the Chief Executive Officer, who answers to the President. So in this sense, it maintains a clear distinction between adjudicative and administrative functions. And in terms of the practicalities, the President of the Supreme Court doesn't really get engaged or involved in the budgeting process, in hiring staff, even though technically he appoints them, or in entering into contracts for the supply of services to the court, etc. All that is carried out by and on behalf of the Chief Executive Officer by the court staff. In terms of the CEO, a little bit more detail. They are under a statutory duty to carry out their functions consistently with any instructions given to them by the President of the Supreme Court. So control still resides in the President's hands. Equally, they are under a statutory duty to ensure that they use and they put in place systems, consequently, for the court's resources to be used so as to provide an efficient and effective system to support the court carrying out its functions, its business. So again, we see a statutory duty here, setting out quite clearly the role and the scope and the requirements by which the CEO has to act. They're also required to determine the number of court officers and staff and their terms and conditions of service. So we see here again, we see this division of responsibility between the President and the CEO, with the CEO very much focusing on the actual administration and the actual management. Consistently with HMCTS, the CEO can be appointed from outside the civil service. They can be appointed from within, and so far they have been appointed from within the civil service. But insofar as they bring experience from outside, if they're appointed from the private sector, they will be deemed to be a civil servant during their appointment. So as a consequence, they will come under, if they're not civil servants, civil service terms and conditions, and therefore the statutory duties that the Constitutional Reform Act imposes upon civil servants engaged in the administration of justice. So again, the CEO cannot act in a way that would undermine adjudicative independence. So that's the UK models. More broadly, internationally, what we see is a movement towards the establishment of judicial councils or boards to run court administration, which are generally analogous, with obviously local differences, to the HMCTS board structure. But what we see in the development, particularly over the last 20 years or so, of boards and councils with responsibility for courts administration, is we're seeing a move away from judicial preponderance or control of those boards and councils. And the reason why we're seeing that is very much to, first of all, promote greater accountability. Oh, that was a slightly anticipatory slide there. Movement. Let me see if I can get back onto the right slide. I appear to have lost. Technology always gets you out of the way. There we go. So to promote greater accountability, but also to promote greater professionalization. So it's a move towards the use and the appointment of individuals who have specific expertise, training, experience in administration and management. Underpinning that is at least an implicit, as I put it, acceptance that judges are judges. That's what they're trained to do. That's what they're expert in. And it's best to have, as we might say in England and Wales, horses for courses. And where administrators are concerned, you need experienced ones, experienced finance officers and experienced managers to carry out the administration itself. So that's why we see a general trend internationally away from judicial preponderance. And we can see this, and I've just got 3 examples here of different approaches. We can see this in Norway. The Judicial Council there, which has a general oversight, has 4 judges on the council, a court executive, so somebody with administrative expertise, 2 lawyers to bring legal expertise or to represent the professions, appointed by the executive, and 2 representatives of civil society, so that's the accountability aspect of it, appointed by the Norwegian Parliament. Equally, in Ireland, we see a similar type of approach. Their structure is quite similar to that in England and Wales, but their overarching board has 9 judges and 8 non-judges, and the non-judges are government officials, trade union representatives, MPs, lawyers, and again, we see the idea here to bring expertise and professionalization, and of course, a representative accountability. Possibly the most sophisticated model is that in the Netherlands, which has a 3-part approach. It has, first of all, at the highest level, a judicial council, which has overall responsibility for courts administration and has had that since 2002. That is separate from the judiciary. It's a non-departmental executive body, but it's at arm's length and is functionally and structurally at arm's length from the Ministry of Justice, from the executive. And it has 4 members on it, 2 of whom are judges, and 1 is a finance expert and 1 is a management expert. So it has professionalization, it has expertise, and it has judicial representation on it. The role of that judicial council is 4-fold. First of all, it is to support and improve the court's working methods. Secondly, it's there to ensure that the courts modernize and improve the quality of the administration of justice. Thirdly, it is there to promote legal quality of adjudication. Now, that means carry out research, on how to improve adjudication. It doesn't mean get involved in adjudication. It means scrutinise, make proposals for reform. And finally, it's there to prepare the court's budget and supervise its implementation. Sitting under the Judicial Council are two further bodies. On the one side, there is a Council of the Judiciary, entirely made up of judges, and they're responsible. And they're responsible for judicial management. So that's looking at adjudicative issues, judicial functions, listing, deployment, case management, taking decisions, etc. That's solely, as I said, made up of judges. And on the opposite side to that, and again still under the Judicial Council, are courts boards. Now, these are responsible for the day-to-day court administration. They operate under the overarching supervision of the Judicial Council. So they have the practical day-to-day expertise, experience in managing and running the courts. And of course, the three work together, so it's an integrated model, but one, of course, which sits under the Judicial Council, which is split between judicials, members, and experts in management. And the one point to make, and I highlight on the slide, is that judicial members who are involved in and who sit on the various councils and boards are only appointed if and insofar as they have administrative management experience. So again, the focus is on improving and on professionalizing. So turning to the final section, where does this take us generally when you're considering reform of courts administration? So I think the first point is that you need to be clear, or anybody who is engaging in this needs to be clear on what exactly your reform aims are. Now, in terms of the international consensus, it appears that the reform aims generally taken are those which promote efficiency and quality of administrative management. So effective planning, financial management to improve the quality of administration, effective use of technology, which of course now also means looking at innovative technology and how to implement that, how to operate it effectively, how to train judges in its use effectively. It also seems to require the promotion of uniform management across courts. Of course, that clearly links in with equality before the law, equal access to justice. We also see the introduction of board approaches to senior management, whether it's Ireland, England and Wales, Norway, or particularly the Netherlands. And underpinning all of this, we see increasing accountability, which of course, if you're increasing professionalization and the quality of administrative management, you're raising the bar at each stage there. And also increasing transparency. So Parliament can scrutinise, the public can scrutinise exactly how the courts are being administered on their behalf. The next point to make in terms of any design principles is to ensure that if you're considering reform, and insofar as you are doing, don't conflate adjudicative independence with administrative independence. You can have one without necessarily having the other. But equally, if you are going to implement any reform to administrative systems and your court administration, you have to ensure that it does not undermine adjudicative independence. And of course, there are methods to do that, whether it's through statutory duties, statutory limits, etc., on the exercise of power in terms of administration. And of course, that then turns us to the legislative framework. And particularly given the English experience, the UK Supreme Court model in terms of having a legislative basis is definitely one which I might suggest is preferable to the HMCTS model, where there is no statutory underpinning for the partnership which is in place. And of course, if you have legislative underpinnings, as I believe one of the suggestions is in Nigeria, that will help to ensure constitutional stability, as well as clarity, transparency, and clear lines of accountability, depending on to the extent that you set those features out within your legislative structure. And I would suggest that that may be something to give significant consideration to. What about management? So in terms of management, one thing we may see as a general approach or a best practice is for the Chief Justice to appoint the board and the Chief Executive Officer, except for those board members insofar as you take this approach, which are nominated by the executive, parliament, or civil society, or the legal profession more broadly. But the Chief Justice or Chief Justices should be responsible overall for those appointments, I would suggest. In terms of the board itself, a board or a judicial council structure seems to be best practice. Again, I would point perhaps to, again, the UK Supreme Court, the Netherlands model, or HMCTS to look at for inspiration there. But again, best practice does see a mix of judicial and non-judicial board members. And I think possibly here, this is something which is best to specify in legislation, again, for clarity and for accountability in terms of exactly what your mix is. But, and again, this might best be specified in legislation, board appointments should first of all be required to have a proper understanding of judicial independence, both institutional and decisional, but equally where you're looking at the appointment of CEOs, CFOs, executive directors, etc., they would be required to have senior level management and administrative experience. So again, it would be best to set out the requirements for professionalization and expertise within the legislative model. And that's particularly the case for any CEO or CFO. Experience of management in a corporation of a significant and comparable size to your courts is, I think, a sine qua non of appointments, with them then reporting, once appointed, to the Chief Justice, with functions concerning administration delegated to them from the Chief Justice if you are going for a judicial model rather than a partnership model, with the CEO, as in the UK Supreme Court, then ultimately responsible for appointment of court staff and their terms and conditions. Now, in terms of appointment, and this will be a key issue, I am sure.
John,
yes?
You're 10 minutes over your 30 minutes.
I am. Oh, I am so sorry.
Yes.
This is the penultimate slide. Sorry, you should. Sorry. I do apologize. The final point that I will make is that in terms of appointment of the Chief Justice,
I've been overruled. My Lord Justice Zana says he's enjoying what you're saying so much, you should just continue.
Oh, right. Well, that's very kind. In that case, I shall. In terms of the CEO and the CFO, I think that the key point here is to ensure that they have the expertise in terms of management, and they have the professional expertise. And while the appointment, I think, in a judicial model should be by a Chief Justice, I think the best way to ensure the expertise is obtained is through an open and transparent competition for the appointment. And ideally, the ideal way to do this is to carry out an appropriate executive search, and there are obviously companies that can do that, that would then recommend an appointment, or that would recommend a range of potential appointees that the Chief Justice could then assess themselves and appoint. And I think in this sense, your CEO, your CFO does not need to be a civil servant, does not need to be somebody with executive experience in the executive, because I think that would unnecessarily limit the field of expertise. And again, though, once appointed, they should be accountable to the board, and they should be accountable to the Chief Justice. And an important point here, they should be accountable to Parliament, to the CFO and the CEO, for the use of the budget given to the courts. Now, there's an important rationale for this. If the Chief Justice were to be accountable themselves to Parliament for budget use, and they had to say, as here, they would need to go to Parliament to answer questions from a parliamentary select committee, any criticism of the Chief Justice or probing questions might potentially undermine judicial independence. So one of the things that you may need to consider is how exactly you properly can insulate the Chief Justice from parliamentary accountability so that it doesn't undermine judicial independence. So in that sense, imposing the statutory responsibility for the budget and for accountability for the budget on the CEO or the CFO might be an important consideration to take. And this truly is my final slide. Finally, the final four things to think about in terms of legislative reform. First of all, the aim is to improve the delivery of the administration of justice and the rule of law. That should be the underpinning of everything that is done. You achieve that, I would suggest, by professionalizing management and administration. But that can be done, as it has been done in other jurisdictions, in ways which are entirely consistent with adjudicative independence. And hopefully, and finally, when it's achieved, you will be able to ensure that public confidence in the justice system and the delivery of justice is promoted. And of course, you're enhancing the rule of law in doing that. So with that, I shall stop sharing the slides, and I apologize for going over my time, and I hope that was helpful. Thank you.
Thank you very much. Thank you very much, John. I think you justified the billing. I don't think I over-advertised your expertise. I think you've shown it in more ways than one. I think what you said really, when I sent, as I said earlier, and sorry, before I continue, I must recognize the presence of our chief host, the Honorable Attorney General of the Federation, Prince Lateef Fagbemi said. You're welcome, sir. And also the presence of the chairman of the body of benchers, Asiwaju Adegboyega Awomolo said. You're most welcome, sir. I think, John, one of the things that I'll share with you is that I was saying earlier that myself and Justice Zana had been having a long-running battle about the NBA proposals for professionalizing the administration of the courts. And Justice Zana came prepared for this session to battle, But then when he read your slides, he said to me that if he had read the slides before, he would have known that there was really no fight. That you as the expert are actually saying exactly what he had always said, which is, yes, you want to achieve administrative excellence, but you want to make sure that you do it in such a way that you don't compromise judicial independence. And I think you've managed to strike that balance. And also, before I hand over to Justice Zana for him to speak for himself, I think one of the highlights of what you've said that struck me is something that we picked up at the session preceding this. When you spoke about the HMCTS, you spoke about the role of the Lord Chancellor and the role of the Lord Chief Justice. This is equivalent to the role of the Attorney General and the role of the Chief Justice. And you said that one of the roles of the Lord Chancellor is to ensure adequate budget and funding for the judiciary. And I'm looking at our chief host. Because at the previous session, Honorable Attorney General, the state attorneys general had been put under severe scrutiny as to whether they are performing their role of ensuring that an adequate budget and adequate funding is put in place for the state judiciaries. Now we can see that even in the UK, where we borrowed a lot of our structure from, that role is recognized, that it is the role of the Attorney General effectively to ensure that the judiciary is adequately funded and budgeted for. It shouldn't be for the judiciary to be going to the executive hand in hand. The Attorney General's role is to perform that. And I know that you are doing that, sir. At least within the 9 months, you've already doubled the budget for the judiciary. And I think also a lot of what Dr. Sorabji has said, really, I think is music to our ears. And I'll leave Justice Zana now to let us have his views on this.
Okay, good. Thank you very much. I must give my respects to our chief host, the chairman body of benches, distinguished and honorable justices here present, and all. I'm a little bit eager to lounge into the matter, so forgive if I messed up the protocols a little bit. Now, I must express my gratitude again to John for making my work. Is it? It's awful. Okay, yeah, good. This is better. So I must express my gratitude to John if he's online, that he has made my work much easier. This work started at the last summit, as Tunde has said. We had a really heated session, and even thereafter, we continued. I remember, I'm happy Bozimo is there too. He's trying to hide. After the session, I still recall, I gave him copies of the framework agreement and the document, the US court setting up the administrative office of the United States courts, and he left them right there on the table. He didn't even pick them up. Well, now you've heard it from the subject matter expert that I did not invite, but NBA invited. So I will assume with that, a lot of ground has been covered, just like I told Tunde, that I've seized my sword after going through the slides. I mean, in fact, 75% of the job is done. What next is just what I'm going into. We've heard clearly from this that it's not best practice, it's not reasonable practice, it's not constitutional practice to hand over the judiciary, the administration of judiciary to the executive, either overtly or covertly. So, and what the NBA bill, which has still been circulated, even to the present this thing, attempted to do was exactly that. I even mentally call it the Governors Forum bill. I don't call it NBA bill, because almost all the board is up. In fact, all the board, except for probably that of the bar, maybe that too was not clear, were to be appointed by the governor, directly or indirectly. And we've, from the proceedings of yesterday and today, we know that whatever safeguards you bring, things like it should be advertised, management firm should be employed, and all these things. I mean, I think Mrs. Adekoya SAN yesterday gave us the terminology I like. There is what is called packaging. You can write all these things, but I'm sure they will package it. They will follow all the rules, and still that person who the governor said should emerge will emerge. I mean, we're all Nigerians here. We know what's going on. We may not be practicing it, but it doesn't mean we are dumb. We can see it happen, and we know we see it and we can recognize it. So that's clear. That MBA proposal was just a complete handover of the judiciary, of whatever remains of the independence. Let me put it this way, of whatever remains of the independence of the judiciary to the executive. And then the judges, as I keep saying, under that bill would have been just kept judges, not the judiciary, just judges that when you want to patronize, you patronize. In fact, probably the ex parte orders will start being issued from the government house, blank copies of ex parte orders. So let's leave that out. I think from our discussions, it's very clear now that that's over. But the issue is not over, because it wouldn't have been if there weren't a problem. This wouldn't have arisen. In fact, when we started practicing this constitution, I can recall that there was by and large satisfaction, especially in the days of my Lord Justice Salami Anko. Why is it now that the very Bar Association itself is the one raising these issues? So I'm talking to my colleagues, and unfortunately, the elders are not around. The big ones that I would have really wanted to be here so that we talk the home truth today are not here, but I'm sure they'll get to hear it somehow. So why is it so? There is a reason. There is dissatisfaction. And I think, in all honesty, it's for good reason. If the judiciary were delivering, you wouldn't have had this. Wouldn't have had this session, whatever the system we're operating. And it's good to even recognize what system we have now going, I mean, having in mind the presentation of the lead expert. What we have is still more or less the partnership model. The state judicials at the state level, at the state level, the judicial service commissions of the state, the JSCs. Yesterday, somebody made the good analysis. It's like 5 state appointed by the governor. And he even said who he appoints and all these things. So nevertheless, there is a wiggle room. The wiggle room is that whatever it is, decision they take there, when it comes to the administration, it is now the chief registrar. And that is where I must talk to our colleagues. Why are we having the problem? If we were doing well, the issue wouldn't have arisen. It would have been just solely a direct issue of funds, whether funds are available or funds are not available. And time was when the bar was actually, that was all they were doing, give more money to the judiciary. Now, that's for the state level. There are issues there because the funds may not be there for us to know whether the system is even working or not. In the setup that Gombe has, how do you even know whether it is administrative problem or what problem it is that is hindering the smooth administration of justice in that state when there is just absolutely no money? And if you appoint an administrator of that caliber that you want, I'm sure the entire budget of the judiciary that they get now will not be up to his remuneration. And if you are not ready to pay him that, he's leaving the next day. Where will you get somebody who will be prepared to work with that level of expertise for the Gombe State judiciary under the budget that they now have? So these are the real issues that are now before us, I assume. I want to go back and now to the federal courts. Now that is where the issue lies. In all honesty, I believe we can make a better case. We could have avoided this at the federal court level. There is sufficient funding to show better results, let me put it. I won't say it's good, it's perfect. No, it's not perfect, but there is sufficient. Now, the entire program is anchored on the fact that there is dissatisfaction with the delivery of services. And if anybody is frustrated, probably I'm the number one frustrator in this house today. I'll give you an example, and I'm glad I'm not deviating, because effective use of technology is one of the aims. What should be the aims of our undertaking, as our experts said, and I'm home and dry. I'll bring the example. Under the National Judicial Council, there was the program, the Judicial Information Technology Policy program. Under that, we've developed a software for filing, for complete automation of the courts, end to end. And I'm not talking about this quick Jankara software. This is a perfect end-to-end automation. CJ Delta is there. She started in Asaba, and I must put it on record that they have already given us notice that they have acquired the hardware to now expand it statewide. Bayelsa is using it, Borno is using it. Now, all it takes for any court, any high court in Nigeria, be it state high court or the federal high court or national industrial court, to deploy this is 2 computers per court, preferably 1 desktop and 1 laptop, just a few depending on the size of the court for the registries, for the litigation registries, and internet bandwidth. That's all it takes, nothing more. Everything else has been done by the Judicial Council. All the licenses, and I'm sure many are experienced here and know the cost of licenses. Why, after more than nearly 2 years of my sometimes bending down on my knees, please, my Lord, let's deploy this in your court. Borno is a remote court around Sambisa over there. Nobody in Nigeria knows that anything is going on just because it is Borno has automated. But I mark you, since October 2020, my hands have not touched a physical case file. And all my duties I perform on this one that you are seeing, this device. 2 computers per court. Is the funding that inadequate? I'll stop here. I have a feeling I should allow Prof to come in before I come back in.
We can argue back and forth, but frustration, definitely there's frustration. We can do a lot better. And I'm sure, Prof, from my discussions with Prof, I think it will be a 3-way competition. So, Prof, over to you.
Thank you very much. Chairman, all protocols observed. I think we should isolate the issues. What are we agreed on? And what are the points of departure? We are agreed that there is a problem. The courts are not functioning well. We are agreed that judges are not sufficiently skilled to administer. Their skill is to adjudicate. We are agreed that judges should be insulated from scrutiny and their independence be maintained and sustained. We are agreed that if judges are the ones who spend the money, then they need to go to Parliament and explain how they spend the money, and we don't want that to happen. We are agreed that a professionalized service is required. The next question, therefore, is who is best, from part of the agony expressed by my Lord Justice Zana, who is best placed to appoint the administrator? Of course, the preponderance of opinion from the judicial side is that it's their job. So we have an example. We have the NJC right now. The CGN appoints virtually everybody in the NJC. We are still not happy. And that's an example of a system where the judiciary decides who they want to manage the things. So is the silver bullet the person who appoints, or should we strongly consider this matter of partnership? That's number one. I'm an academic, and part of my job is to look at whether the thing is running the way it ought to run and is functioning the way that it is anticipated. There's no doubt that it is not. And I ask myself the question, what is the interest of the judiciary to have courts that are fully functional, to have their independence? We are all in agreement about that. So what is wrong? For example, the judiciary says we need 10 courts in the next 1 or 2 years. Must they build the courts themselves? Must they build the courts? They need 10 courts. They've done their plan based on the workload. They have their input is taken into the design, the functionality, the comfortability, and all that. All that is taken care of. They make input. Why insist that you have to build the court? I've asked that question in Lagos because I was very actively involved in the reform system in Lagos and all that. So we need to separate the wheat from the chaff and be honest and all that. We talked about funding, and we were all in agreement that we have to do something about making sure that the judiciary gets the funds that it deserves. Part of the problem is from the budgeting. Thank God for all of us who are in this room, all lawyers. So if we are not judges, we have classmates who are judges, or we have relatives who are judges and all that. I've asked my colleagues, my friends who are in the judiciary, how do you prepare your budget? They say they don't know. How do you know? I headed an institution to prepare the budget for the fiscal year. We sat down and evaluated what was our priority, what we needed to do, and what we needed to sacrifice, what needed to go up, what needed to come down, based on trends. And then you make some projections, because with a budget, you also have to be a prophet to a limited extent. They said they don't know. So somebody just decides this is your budget. Somebody just decides this is your budget. That's point number one. Secondly, the present system is not ideal. I'm not justifying it. But one position that I've taken for quite some time is that at the basic level, if somebody tells me the money you are giving me is inadequate, and I know that the state courts have made a very strong case, and I do not disagree with it. But when you say the budget is inadequate, you have to explain how you spent it. You can't just say it's inadequate and we accept that it's inadequate, even though on the face of it, it appears to be inadequate. But you still have to explain how you divided it. So if your budget is single line, 100 million, and you choose to put 80 on something you like, and then you complain that the remaining 20 is not solving something you need to be functional and effective, you need to reorder the priorities. You need to reorder the priorities. And part of the problem is that the judiciary needs to justify its demand. And the only way to do that is to open the books. And they don't have to advocate anything. All they need to do is to show that this is inadequate. I was saying to a chief judge yesterday, I said, what is wrong with just putting on your website? There are many NGOs all over the place. They take the figure, this is how much. They will look at the budget and say the entertainment allowance of the executive alone is 10 times of this. And they start hitting. Before you know it, something changes. But nobody knows where all the money is spent. Nobody knows what is allocated for where and all that. So, and the same thing impacts administration. So we need to change the template. I mean, there's no two ways about it. That's why I said, let's agree on those things upon which we are unanimous and separate. Now, the proposal of the MBA, which has been somewhat modified, and I think there's some agreement on both sides, is to tweak the federal judicial at the federal level, for starters, tweak the Federal Judicial Service Commission, take away all of his role and in policy making, appointment, and give it to the NJC, which will then deal with those issues. And then leave and reprofessionalize the Federal Judicial Service Commission to deal with court administration properly. And in doing that, to take account of some of the things that John said, which is to get a professional. As I said, the judiciary can be given the power to appoint the professional subject to clear guidelines, criteria. Because otherwise we will be back to square one. Somebody will appoint somebody they know who is their friend, their cousin, their brother, their whatever, subject to clear guidelines which are made public and can be assessed and evaluated and critiqued, because otherwise we'll be back to square one. Somebody has asked the question, what happens to the existing registrars? Part of their job is to look at, support the judiciary on the adjudicative functions, case management. There's an overload of cases right now. Registrars can help deal with some of those issues, working with the courts. But many times when I speak with friends who are heads of court and all that, they say, is the chief registrar. Many chief registrars, with due apology, they are richer than the institution. So we should stop pretending about it. Something just has to change. And the starting point is to throw some light on the process. And since we all agree, judges are not happy with the way court administration is running. I went to see a judge friend, a lady judge in Lagos. She said, this is my printer. I brought it from home. My registrar had just gone to buy paper because I wanted to give her something and I wanted her to print it. She said, Bolaji, me only paper. I said, well, okay. So we need to deal with some of those issues. The judge doesn't have to worry about whether there is diesel and all that. That's the job of the administrator. And if there is no diesel, the administrator gets a query. If he gets well paid and all that, he's given targets. He makes sure judges are then left to think about the disputes before them and how to resolve them. So we have already tried it long enough. We know that the core skill and competencies of judges is adjudicative ability, not administrative. And let me round up my first intervention. Judges are like academics in a way. Professors, the best academics are not the best administrators. That's why you have a registry section in the university, whereby it is the registrar that deals with the university administration and the academics deal with the policy and all that. And to underscore that point, I used to think it was just a fad. When I got to ICPC, many professors who have been appointed to head agencies were my customers. because they lacked administrative skill. They walked eye wide open into easy pits. They just walked in. So I had to start what I call executive saying, when you got appointed, before you got into trouble, since we had a vulnerability risk assessment profile, I invited them into closed sessions. Chatham House rules, you are free to say anything and ask any questions. And then I asked them, do you know anything about the Fiscal Responsibility Act? You have accepted the appointment. You have done Thanksgiving in church for the appointment. You're on your way to jail. Because you don't have the foggiest idea about what the Fiscal Responsibility Act says and the duty and responsibility it imposes on you. You don't know anything about public service rules. You only know about the research. You are well accomplished, known all over the world. And I'm just looking at this guy and say, you're on bail at the moment. So some things, I just said to them that, look, you don't need to deal with these issues. And that was the approach I adopted. As an academic also, there were many things I didn't know. So I will commit the administrators, put it down, that you are advising me that this is doable. Sometimes I'll ask you to bring the supporting document to assure myself that you are not misadvising me. So we need to be honest with ourselves. The present system is not working. What we need to discuss is who is best positioned? What sort of collaboration do we need in order to be able to appoint the person who can make the system work? Thank you.
Thank you so much, Prof. I think, as I said right at the outset, this was the battle lines that were drawn in 2022. I think there's now an armistice because, as my Lord Justice Zana has said, the question, I thought the challenge was with the idea of professionalizing the administration of the courts. But it's quite clear. I think there's a general consensus building around the fact that it is only by potluck that you would end up with a head of court who also happens to be a fantastic business manager. It's just chance. So let us agree that we need to identify good, capable people to administer our courts. As both Justice Zana and Professor Wasonye have said, the challenge now is who does the appointing, what is the process by which the appointing is done in order to maintain the independence of the judiciary and achieve the objective we want. We've made some proposals, and I think Justice Zana has identified that his concern with the proposals was the proposed change to the composition of the State Judicial Service Commissions, because it tilts even more in favor of the executive than is currently the case. Yes, so that is not our focus. Our focus is actually agreeing on the need to professionalize the administration. If the challenge is just with how we appoint the administrator, what the qualities are that the administrator should have, that is something that we can all debate and agree on. So, my Lord, one last word and then we throw it out.
Yes, if I remember, I had my 5 minutes of, and then I said, and allowed Prof to go. So I will use that 5 minutes and then thereafter take my last 5 minutes. Now, I just want to be clear. The Prof says something, and that is the crux of the matter, that he doesn't, it's not important. Or look, let me just put it the way I understand it. He can correct me if I'm wrong. He may be appointed by the judiciary. He's not insisting that the executive should be the ones to appoint. And that is where the agreement lies. My entire angst and opposition is politicians appointing the persons who will come and run the judiciary. That is all. So long as it's the judiciary itself appointing, I have no problem. And that is what our lead presenter said. Clearly, if you have forgotten, I can start reading them. Each you see appointed by the Chief Justice, reporting to the Chief Justice, all through. That is the recommendation. And where you have a situation where it's outside, it's a politician, governors and presidents are all politicians. Even attorneys general, with due respect, you are not here. By the time they are appointed, they are politicians. Because I can imagine a situation where the governor, the president is too much. When I say governor, You yourself read in the other office. Don't let me do that. You say, AG, that thing about the judiciary is coming up. So is our man. He has helped us a lot during the last elections. Make sure that he is the one who emerges. I'm sure it will be packaged. Abi. And if you cannot package it, or can't you do it? I'll do it, Your Excellency. Because if you can't do it 24 hours, there is another Attorney General in office, a capable one who can package. Now, even the safeguards, I agree with the safeguards. And I agree that if it's us doing it, I'm in the judiciary, so let's put it that way. It should be with the safeguards. And I'll give you good news. The packaging ability and packaging capacity of the judiciary is even limited. It's not as skillful as the executive. Do you agree? So this is even where the safeguards will work better. Once we agreed on this, we're now back to frustration. Look, many a time, and by the way, while the Constitution says all amounts standing to the credit of the judiciary should be paid to the head of court, the practice that we have and the laws that we have still make the chief registrar the accounting officer. That is what we practice. So this now leads me to the frustration. Many a times, and it's across so many chief registrars, I'm not singling out my present one or this one, includes him too. They come with decisions to me that make me say, look, CR, what is your job? This is not my work. Tomorrow, they will come. So that is to justify the fact, the need for the professionalization. A professional administrator wouldn't have come to me to bother me with this thing. India is bothering me to participate in the summit. Commonwealth Judicial Education Institute is sending me 10 emails per day. I thought presidency was easy, but I didn't know that it meant sleepless nights. And then chief registrar will come with something about some court somewhere needs renovation. Oh my God, please get away from here. What are you disturbing me for? So it's even in our own interest. And see my gray hair. I'm not as old as my this hair looks. Professionalize it and maybe it will turn black. So there is no disagreement as far as that was. But mine is this: don't compromise the independence of the judiciary by handing it over to politicians and political appointees. Once we agreed on that, let's work it out.
I've made progress. As I said, lunch is 7 minutes away. So we'll take a few questions. Oh, okay. Well, for those of us who didn't go for lunch, it's our loss. Or who didn't go for tea break rather. So, Mr. High Chief BK Ogala SN.
Thank you very much. My name is Babatunde Ogala SN. I think there seems to be a consensus need for administration and professionals. And in reacting, I wish to share some experience. I was a member of the House of Assembly in Lagos. I was chairman House Committee on Judiciary. And we made an attempt. The Solicitor General is here. Moise Banira was a commissioner then. And some judges in Lagos State at the time, the story I'm going to tell you are also here. And I'll start from my Lord. This suspicion, it's a big problem. And you have just demonstrated that, sir, by keep saying politicians, politicians. It's the politician that appoints the CJ. It's the politician that appoints the judges. So I think we should think more of structure and collectively making it work and banish this mutual suspicion. And that takes me to my experience as a member of the House. I was chairman of House Committee on Judiciary, a senior lawyer. First thing I resolved was the CJ was not going to come to the House under my watch to come and defend any budgets. Because a budget for the judiciary, it must go through the legislative process. And imagine the CJ being put and asked embarrassing questions. I refuse to let that happen. Pedro is here. That if I am satisfied and as a member you believe in my honor, then you should take my words for it that we've done a good job. But what do we have? Again, as Chairman of Committee on Judiciary, forcefully against the wishes of the then governor, a lawyer, a senior advocate, and the Attorney General, I used my influence in the House to ensure that the capital budget of the judiciary was vested in judiciary. Behold, I regret to say it was mismanaged, that when it was the time for a review of the budget and the report came to me, I was too ashamed to present it to the House. What did I do? The governor then, Pedro, also bear me out, even accused me that my bedroom talk, though my wife was in the judiciary or still is, that I'm trying to translate it to state policy. Because I recommended in the budget that judges should have things like ergonometric chairs because they sit long hours. The judiciary never implemented it, even though I budgeted for it. They never did. Rather, what did we have? The same judiciary spent as much as 200 million planting flowers. This is the truth. When this report came, I was too ashamed to present it to the House, but that would have entailed the CJ being brought. Some of these things became EFCC showed interest, but again, not to ridicule the judiciary, we killed it. We killed it. The Solicitor General is here. I mean, we can say so. We killed it because I could have imagined bringing my judges to EFCC or the CJ. We couldn't hear of it. Again, lack of professionalism. You use the chief registrar, who you also pick from the magistracy. It's just one of you. No experience. So, sir, my humble view is we must banish, and then the issue of administration. We also experimented with the magistrate court law that was promulgated by the House after a public hearing where the judiciary made a submission. What did we attempt to do? Magistracy was they are being paid as civil servants. We thought it was low. They are judicial officers, as far as we were concerned in Lagos. We tried to professionalize it, also to reduce the pressure on them wanting to move to the high courts and move their salary. I think we said minimum 300,000 a month was what we thought a magistrate in Lagos. If doctors and consultants are earning as much, why not magistrate? As at then, we promulgated our law. We thought of an administrator, and I think Professor Wasonyi was there in Singapore and in Vancouver when we visited the courts to look at how they administer their courts. And we came to replicate. They call them courts of limited jurisdiction in Singapore, the magistrate courts. And we said, let us take it away. Let's raise the bar. Their salaries were top heavy. Chief magistrates all had reached the peak. There was no opportunity to move up. But if you can at least close some gap, we even said we should make them robe in Lagos. They robe in Lagos. We put all this together and we said, let professional administrators manage the magistracy. What did we get in return? We had a public hearing. The judiciary made a submission. This law was promulgated. Behold, Lagos State Judiciary sponsored a suit to kill that law till today. The honest truth. They said they wanted to take over powers of the CJ. In fact, it was even said, rumored at that time, that I wanted to be an administrator.
Yeah.
But again, it was part of. So, sir, I think the suspicion by judiciary, because this, my lord, you have said it over and over, as long as it's not politicians. And you are saying Attorney General is not a politician, but once he's appointed. Being a politician does not confer less responsibility. I am one. No,
Are you saying it should be done by the politicians
My lord,
or by the executive?
my lord,
Hmm.
I believe what we should concentrate on is the structure.
This is English.
No, sir.
Let's
Sir,
bring it down.
Well, my lord, with all respect,
You want to be practical.
my lord, my lord, sir. It is the structure. Today, what is the practical thing? We won't pretend not to know that even in the appointment of judges, some CJs carry their list to the governors for approval before sending to NJC. We might say all the good talk. I've been involved and I'm still involved. And some of us also we fight more because of the judiciary than the judiciary itself. I'll just give you an example. So, sir. So, my lord, with all respect, sir, what I'm saying here, sir, is we should concern ourselves more with building structures, reduce the suspicion.
What type of structures are you recommending, Chief Ogara?
Structures, be it legislative, have the mode of appointment of administrators, it will not matter. To insist it has to be by the judiciary. By the token that the chief judge of a state appoints the administrator. We could well say the administrator is also not independent. Because when we talk about independent judiciary, there is also internal interference.
Okay.
Which is also
your view is noted. Your view is noted.
So I'm saying, sir, that we should banish this suspicion. We should try to build enduring structure. So being politicians, being on the executive, they are supposed to be complementary. And as of today, the executive is unfortunately the senior partner, like John said.
Well noted, sir. Well noted. Let's take comments from somebody else. My Lord Justice Salami wanted to make an intervention.
My lords, ladies and gentlemen, may I know from Honorable Justice Zana of Borno State whether you will consider this as packaging. If a commission allocates a seat to this man, a seat to this man, this to this man, seat to this man, it is 5. Then it conducted test by computer. And by accident, these very people we have nominated before we met came first in their respective states. Is that packaging or what? That's what is happening. This, my friend,
yes, sir,
is Yamat for Oyo State.
Yes, sir. Yes, sir.
For Oyo State. For Kogi State.
Yes, go ahead, sir.
Not Lagos, not Lagos.
Moise is Borno.
For Kwara. For Kwara, and so on and so forth.
Yes, sir.
And we did a test.
Yes, sir.
By computer.
Yes.
And these people already earmarked came first for their respective states.
Already earmarked?
Yes.
Yes, my lord. That is exactly the point I'm making.
And this is what happened.
Yes.
In the selection of would be justices from capital territory.
My lord, okay, if you finish, I will answer you, sir. Since you asked me directly.
No, that's what happened.
Yeah,
accident?
I will answer you.
No, is it accident?
It's not accident, it's packaging.
No, why are you blaming politicians?
I am not blaming politicians, sir. What I am saying is...
So what is happening?
Okay.
In the present...
Thank you, sir.
Two.
Yes, sir. Yes, sir. Can we finish with one? Can I answer the one?
You can.
I don't need to answer, sir. Okay, sir.
People have understood whether you answer or not. 2. Are you agreeable with the present composition of NJC? 2 CJ have been forced to retire, to resign before their time. because of the operation of NJC.
I think the point, my lord, is making is that whether it is politicians,
And
whether it is judicial officers, if you don't have a structure in place that prevents packaging will occur.
And me, lastly.
Okay.
And me, I'm under the present NJC. And me, as a living example, do you agree that the way they manipulated my exit was proper?
My lord, have you finished, sir?
These are not.
I will answer, my lord.
They are just.
My lord. My lord, we work together very well. It doesn't matter. Correct. I think that is the point I made earlier. That maybe implicitly that's why it didn't come out clearly. I said even the safeguards would work better if the appointing is by the judiciary, because they lack packaging ability, packaging capacity, packaging resources as well as the executive. If they had it, you wouldn't see it so clearly now. Would you have? The one that is going on in the executive, you don't even notice that it is being packaged. This is because they package so well.
Thank you, my lord. You can see that this is now a packaging debate. Professor Wasoye.
I think what Justice Salami is trying to tell us is that the difference between the judiciary and the politicians or the executive is the difference between 6 and half a dozen. So, and that without prejudice to whoever is doing what, if there is no integrity or character, you will get the same malafide result.
More interventions? Yes, Professor Oyewa, please.
Thank you very much, Mr. Chairman. I think the point has been made by Justice Zana and Justice Salami and my friend Delana Sirk. One thing we must acknowledge is the principle of democracy and distrust. There's distrust between the arms of government. There is distrust within each of the arms of government themselves. And the only solution is what the NBA has preferred. Let's have these mechanisms spelled out. Even if the Constitution has not spelled it out, let's have legislative, specification that will guide even the selection of the software. I can give you an example. In my state, we wanted software to be used by the judiciary. And we had a forum of Southwest Attorneys General. So we invited software, providers of repute. And then from there, we asked them to apply to the state. And then when I got back to the state, I informed the head of the judiciary then. And they said, oh, they've already done it. They gave it to somebody that was recommended by a retired judge. And I can bet you what they did, it's not working. So bottom line of it is that packaging, it's interest. It's financial interest. When there's money involved, darkness will come in and light will dim. The only thing that can shed the light is the law. And that is what we are doing here. Let's specify a legislative prescription. How do we appoint this? If there's distrust between judiciary and, let's counterbalance. After all, there is no clear separation, absolute separation of the arms of government. So checks and balances should be brought in. And we are lawyers. Examples, everybody that has been in government has one example or the other of packaging of interests, of children, of wives. I got to the ministry where I was, and the previous government had employed 25 people at the exit 2 days before they left. And out of the 25, 20 were women, children of this, wife of this. Only 5 were men. And those 5 men too were the brothers. So I just approached the governor that, please, let's redo this process. Terminate them lawfully and let them go through the new process of examination. Out of the 20, I think only 3 of them eventually were able to come back. So Nigeria, we don't trust our shadows. So that's the way we are wired. And so we need to go from the traditional way of doing things to a more constructive, transformative approach that relies on the instrumentality of the law that was specified by legislative, by subsidiary legislation, so that either CJ or the administrator or whoever, there will be clear deliverables, there will be clear measure of performance index, and there will be clear process of assessing whether the person is meeting, and there will be clear, process of determining where we are going. As Shakespeare said, we must know where we are before we know where we are tending. Thank you very much.
Chief Edigwe, please.
Thank you so much. I'm a bit worried that it looks as if we have veered away from the subject. So we are talking about the policy and what sort of structure we should suggest for the administration of the courts. But most of the discussion have been on protecting positions. I think we should go back and agree on the fundamental, and then it's very easy to decide which model will follow, whether it's partnership model or judicial council model. And the fundamental thing we need to agree on is that whilst there's separation of powers, there must be checks and balances. The question is, do we agree with that principle? That whilst there's separation of powers, there must be checks and balances. If we agree on that fundamental principle, then nobody will make an argument that the judiciary should alone control the administration of the court system, or that the executive alone should control the administration of the court system. It's very simple. You either agree or you don't agree. When I did constitutional law, we were told about Montesquieu saying that absolute power corrupts absolutely. Therefore, you should divide power into 3 branches of government, but have checks and balances, which means that they will still interact in one way or the other in performing their duties. And then when I went to do my MBA, very interesting, because a comment was made that people don't trust themselves. During my MBA class, we were taught that if there is too much peace in your organization, then you are in trouble. You must ensure that there is reasonable conflict going on. That's when it's difficult for conspiracy to take place. So quite frankly, I don't care whether there is a conflict going on between judiciary and the executive and the rest, and whether executive member is going to be in the partnership, etc. Because you need that conflict to prevent the absolute power, whether in the executive or in the judiciary. It is needed for our system. So if we agree on that principle, then we go back and say, okay, what is the best of all that has been discussed? Because apart from the presentation from the gentleman from England, we heard yesterday the model of Kenya. And what do they do in Kenya? They have a judicial council system, but to prevent absolute power within the system, The membership is elected by peers. So you would have the CJ making some appointment, then you would have the Court of Appeal judges electing with a tenure their own members. You will have the High Court judges electing members to the governing council, and then you have the bar electing their members, not the CJ appointing. I think we should be thinking about that Kenyan model if we really want to solve the problem here. And the issue has been said that, it means, let's say, for instance, they say body or senior advocate should elect their own members directly. That means somebody will control it at the body of benchers. Well, I say yes, let the person in the body of benchers control those who will come to represent body of benchers. Let the CJ control those who will come and represent him. Let them have the conflict there. Then the risk of conspiracy will be limited, and they will focus on the objective. Thank you.
Thank you, Chief Idigbe. I think that I was going to say I think that we will close it there, but the Honorable Attorney General wants to make an intervention. Yes. I think it's an intervention.
Well, I stand on existing protocol. I had some anxious moment whether I should talk or not. But at the end of the day, my take is that I'm still a member of the legal profession, and that is what we are discussing, justice. I want to thank those who made the presentation both yesterday and today, particularly Honorable Justice Mutunga and John. You see, we have to be very, very careful. Like the last speaker said, the concept of checks and balances, you cannot wish it away. It depends on who you are talking about or which of the organs. Is this the legislature? Is it the judiciary? Is it the executive? There's no way you will not find corruption, misgivings, and all these atrocities. Take that home. So if you say, oh, the way the National Assembly is going about it, we don't want. You say judiciary, manage your own affairs. The way the executive is treating the judiciary is not good. Manage your own affairs. You will live to regret it because we'll be worse off than where we are going. It's not about theoretical issues, it's about the practical issue. And I hope my eardrums are okay. And the point I've always been trying to make is that it is better to have good men administering bad laws. I've always emphasized that than having bad laws. Bad men administering bad laws. It depends on who is there at a particular time. But I agree that we should try and streamline what we want. John took us to Canada, took us to various countries, each with its own peculiarities. Tito, Justice Mutunga, what this tells us is that we have to be inward looking, see what peculiar difficulties we have and how we can wriggle out of it. It is not a threat, but let me warn. If you do it in a way that will throw up the issue of checks and balances, you may not have your way. I wish you well.
Just before we close, my Lord Justice Dana wants to explain.
Yes, I want to explain the context. If you have not seen the NBA bill proposed as is now, you are not getting it. There are specific provisions there whereby 90% of the persons in the board, the CEO, are going to be appointed by either the governor or the president. Full stop. That is what I said. That one would not work. That is not check and balances. That is handover. Yes. So, and again, let's go back to our lead presenter. He made it very clear. Adjudicative independence should not be conflated with administrative independence, right? But administrative systems, we should ensure, do not undermine the adjudicative independence. If you have that one as proposed by the NBA, there wouldn't be adjudicative independence. We are all Nigerians, you all know it. Where persons completely appointed by the governor or by a president are the ones that will determine if your vehicle is fueled or not, be you chief judge or a judge. Would there be adjudicative independence under such a setup? Period. If we answer this question and we say, oh no, it's okay, the governor can appoint everybody and things will be okay, and you will go and judge your case nicely. If that is the conclusion, fine, let's do it. But one thing is clear, you can reverse things, powers you give to judiciary, but powers that you give to the political class, if this were to pass today, come next year and try to reverse it, you cannot. Thank you.
I think if I may just in rounding up, I think it is clear that the consensus that we have reached, which is the consensus we sought, is that there's a need to professionalize the administration of the courts. The question as to how we achieve it, I think requires a lot more thought. And one thing we had always said, and I've shared this with Justice Anna before now, that the proposals that the NBA made in the bill that was sent to the National Assembly during the last Constitution amendment exercise is not cast in stone at all. We're not married to it in terms of the proposals for recomposition of the State Judicial Service Commissions, for composition of the NJC. What we are married to, which we have all agreed on, is the need to professionalize the administration. The question as to what model we use, whether it's the Kenyan model, all the various models that John shared with us, I think it's work that needs to be done. And Honorable Attorney General, I'm delighted that you're here because we've also been discussing this summit. Initially, if you look at the paperwork that invited to the summit, we had indicated that bills will be presented for consideration. But in retrospect, we realized that it was probably premature to present bills. Those bills are actually going to be prepared and finalized based on the input, based on all what has been said here. So this summit is just now, all that material is going to go into finalizing the bills, taking all the views that have been expressed into consideration, and especially the comparative elements that we've received from our friends from overseas. So with that, I urge you to join me in thanking our distinguished panelists for a wonderful session, especially Dr. Sorabji. I hope he's still with us. John, thank you very, very much. This has been a fantastic session. I think we've all, as a matter of fact, the level of debate shows that we're touching, as Chief Idigwe said, if everything goes smoothly, then that means you're not telling each other the truth. But when you start telling the truth, you cannot but have some friction. Which one is it? That from John or this is in relation to we're doing with.
Yeah, no, it's just general
announcement. Oh, okay.
You get
okay.
But I thought
okay.
And access it online.
Okay.
Sorry.
Absolutely. Absolutely.
There are other ways to share.
No.
Okay. I really.
Thank you very much. I think just a point, Dr. Smith, who spoke to us yesterday on the appointments panel, he's authored a lot of what he said. As I said, he's a subject matter expert. It's already contained in this book, which he had written, The Appointment, Tenure, and Removal of Judges under Commonwealth Principles, a compendium and analysis of best practice right across the Commonwealth. So just to say, the book is available on Amazon and all our other platforms. So just to let you know that for anybody who is interested in digging deeper into the topic, we will definitely use it as a resource for the post-summit engagement that is coming. So thank you very much, everybody. It's now time for lunch.
Honorable AG, I'm working for you. But some of these resolutions.
Please remain behind. And then all the attorneys general of states, your meeting is immediately after this panel. All the attorneys general from the states for a few minutes, you have your meeting, and then all members of the planning committee, please wait behind for a short meeting before lunch.
We're resuming 2:15. Do you have a copy of this? 2:15. Or should I leave it with you?
Let's be back here at 2:15. Let's be back here at 2:15.
Yeah. Because it said he might leave
before the end of the next session. Okay.
Yeah.
So where are we going to take it?
Against this background, if the camera people think it's okay.
Who are they? Do we have camera people, Prime?
Yeah. Because I think this background would be appropriate.
Yeah. So the camera person can come and stand there.
Yes. Why is the
all members of the planning committee, please be on the stage. Come up to the stage, all members of the planning committee. And as we're going for lunch, please be back here at 2:15 p.m. All members of the planning committee, please come up on stage for a short meeting. And then as you go for lunch, please remember to be back here at 2:15 p.m. Members of the planning committee should kindly come on stage. Members of the planning committee should kindly come on stage. Thank you.
LMS, come to smoke cannabis. Doctor say make a pop one of this. Make me fly like say I'm Aladdin. Come bring some kind melodies. Oh, mommy, myself, no do past like this. So many things inside the machine. Start on DBT, DBT. If you want to make a ginger, give me Kokoro. Oh, mama tetema. 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 Oh, mama 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 tetema.
Good afternoon, my lords, distinguished ladies and gentlemen. Please, let's take our seats so that we can have the two final panel discussion for this 2-day summit. Like we did yesterday, we are going to have a combined panel. Sessions 3 and 4, item 7 on your program and 8 will come up on stage like we did yesterday. And then when they are done, we have a combined question and answer session. So for the first one here, eradicating delays in the administration of justice, agenda for leveraging the rules of procedure and effective case management in Nigeria, focus on administration of Criminal Justice Act or laws and administration of civil justice law. Our moderator here, I'd like to welcome here Professor Peter Ape, SAN. These are members of the panel: Mr. Isaiah Bozimo, SAN, Mr. Babatunde Fogunlu, SAN, and Mr. Fernandez Marcos Obiene. That is for the first panel. And as they are finishing like a relay race, they'll be handing the microphone over. Okay, I understand Dr. Uju Agomo will also be joining this panel. Dr. Uju Agomo, please. And then the other panel, which will be on discipline at the bar and on the bench, the case for enhanced disciplinary powers, performance management, and court monitoring. This will be moderated by Chief Anthony Idigbe, SAN. They will be on the other side of the table, and this will be the panelists: Honorable Justice Mohammed El Lawal, Justice of the Supreme Court. My Lord, I welcome you. You're welcome, sir. My Lord, Honorable Justice Olushola Williams, retired. Ms. Hadiza Usman. And Professor Yemi Akinshe George, SAN. So we have the two panels round seated. Professor Peter Ape will finish and hand over to Chief Anthony Idigbe. And after that, we'll take the question and answer. Prof, over to you.
Okay, it's working. My lords, serving and retired, learned senior advocates of Nigeria, may I especially recognize Chief Adegbuyega Awomolo, senior advocate of Nigeria, fellow of the Institute, Chairman Body of Ventures. Thank you. Esteemed members of the bar, ladies and gentlemen, it's my privilege to moderate this session, which I consider to be perhaps the most important of the sessions we've been considering, because it's dealing with a subject matter that affects all the stakeholders in the administration of justice system generally. This session will focus on eradicating delays in the administration of justice. We'll be looking at an agenda for leveraging the rules of procedure. We'll consider case management. Of course, we'll also focus on the Administration of Criminal Justice Act and the state laws, and of course, the Administration of Criminal Justice Law. The idea is to see how these mechanisms can help us to eliminate retrial delays that we have in the system. As you are all aware, a lot of factors have been identified as responsible for the trial delays experienced in the justice system. Many of them, many of the literature in the area actually does suggest that some of the factors identified include tardiness of counsel, permissive rules of court, poor use of case management techniques, inadequate infrastructure, inability to leverage technology, and of course, in some respects, inappropriate constitutional provisions. So to enable us interrogate these issues, our esteemed panelists have been carefully selected. They are seasoned practitioners and reform advocates who will be weighing on some of the issues that we have outlined for discussion. So without wasting time, I would like to quickly turn to my colleague on the left, Mr. Babatunde Fagbunlu, SAN, and I would like you to perhaps, from your vantage position as a seasoned practitioner, can you, in 2 minutes, quickly just outline what you think is responsible for the delays in the trial system in Nigeria? Thank you.
Thank you, Prof. And please permit me to stand on existing protocols. Good afternoon, ladies and gentlemen. My involvement in justice reform, civil justice reform, dates back to 2004, when I served on the Justice Ilori committee that resulted in the new civil procedure rules that brought about front loading and all of the things that we know today. I was full of so much expectation at the time that we'd found the answer. Today we are here 20 years later, still talking about justice reform. Clearly we had not found the answer. I think the answer lies in the people, not in laws. And I've heard many people say that to me already. So why did we in 2018 decide to draft an administration of civil justice bill, which incidentally has now been passed by 2 states, Ekiti State and Delta State, and we are hoping will be passed by the federal government so as to cascade down to all of the states in the federation? Well, because while we know that the problem is with people, not with laws, and like somebody said earlier, it's better you have good people administering bad laws than you have bad people administering good laws. We nevertheless think that at the same time, to leave the fundamentals of civil justice to rules of court and practice directions does not help the problem. Perhaps you need some kind of, and I say this in quotes, constitution of civil procedure, some statute that sets down the fundamentals that you cannot derogate from. Let me give you a simple example. I think it was in 1998 that the Supreme Court decided Kotoya and CBN. And when the Supreme Court decided in the context of abuse of ex parte orders, I'm sorry, sir. Yeah, in the context of abuse of ex parte orders. And when that decision was given, I was still a student then. We thought, yes, that's the solution. Ex parte orders won't be abused anymore. They are still being abused till today. And that's because you don't have a statute that lays down the mandatory fundamentals. And that is why we thought there is a need for administration of civil justice system bill. Now, I'm going to talk about only just 3 things. Because of the limited time, I'm going to talk about only just 3 things, which I think are responsible for our delays from a rules perspective. And that is number 1, laxity. Laxity. We do not take court business seriously. We don't. It is reflected in the court is not sitting syndrome. I don't know how many WhatsApp messages I've received from the Court of Appeal to tell me that the court will not be sitting. The court will not be sitting. I receive it almost every week. I traveled to Abuja to do cases. I step into the court and I'm told the court will not be sitting. Right? I come from Lagos. And so the court is not sitting syndrome. It's a problem for us. We need to recognize it. We thought there was one of these sessions where we had said to them, well, if you're not going to sit, let us know in advance so we don't have to travel so far. And so with a lot of enthusiasm, we started receiving notices, court will not sit. But that's not the problem. Why should the court not sit? That is the problem. That is actually what the problem is. So that's 1, laxity. We don't take court business seriously. The second one is manipulation, gaming the system. And the two elements under that I will talk about, if I get more chance to do that, is the way we abuse interlocutory appeals so that we can get stay of proceedings, and the way we abuse ex parte orders. I've talked about that already. Then the third one is we have completely circumvented the filtration systems that have existed ever since the civil procedural rules were formulated. And I'm talking 40s, 50s, 60s. There are filtration systems in those rules, but we subverted every single one of them. There is application to strike out for not disclosing a reasonable cause of action. There's summary judgment. But today, it's very difficult to move those types of applications successfully. And why is that the case? One judge had said it to me before. If I grant your application to strike out this frivolous case, how will it count for me in the National Judicial Council? Right? So that's one reason why strikeout applications will not be granted. Another one is that, well, and this is another representation I've heard from a judge. Well, let him have his day in court. Let him call his witnesses. After all, there's a provision on fair hearing. Fair hearing does not entitle you to prosecute a frivolous case. So we need to reshape our understanding of what fair hearing is all about. So those are the three things that I will identify for now. I hope I get a chance to elaborate on this a bit more and on how the Administration of Civil Justice Bill seeks to cure these as well as other problems. Thank you very much.
Okay, thank you very much, Fagbolu SN. Mr. Bozimo SN, let me turn to you. From your vantage position as Attorney General former Attorney General of Delta State, what has been your experience and how do you think the Administration of Criminal Justice law of the state had operated, particularly in dealing with issues of prior delays?
Thank you very, yes, it's working. Thank you very much indeed. Let me first, excuse me, also stand on the existing protocol and thank the organizers for inviting us to contribute to this very important discussion. Well, for us in Delta State, we had the Administration of Criminal Justice law that was enacted, I believe, in 2016 on the back of the Federal Administration of Criminal Justice Act. And as we all know, the purpose of that was to deal with what we perceived were the agitating factors in criminal proceedings. And the whole idea of the act, and to some extent it worked, to some extent it did not, was to deal with some of these problems. From the Delta State perspective, we saw that the act was not quite working as intended. We saw that, for instance, when we went on prison visits, and we will see that a number of cases are not moving forward for a number of reasons. Inability to provide witnesses, inability to deliver the Attorney General's opinion. So we felt that the spirit and intent of the law was not being delivered as expected. So what we did was to identify what the bottlenecks were. We wanted to approach it from a very empirical basis. And we did a call for memoranda at the first instance from all the stakeholders in the criminal justice sector. We requested memoranda from the judiciary, from the Nigerian Bar Association, from the Nigeria Correctional Service, from civil society as well, and internally from the Ministry of Justice. And we were able to identify where some of these bottlenecks were. For instance, from the Ministry of Justice, we found that it was taking an average of 6 weeks for the Office of the DPP to render advice. And without that advice, cases will not move forward. From data from the prison visits, we were seeing the number of instances that prosecution was unable to provide or present witnesses. And again, that will stall the proceedings. So based on the memoranda we received, we put together what we felt were the solutions to some of the delay bottlenecks. And we had 2 rounds of public consultations. The first rounds, we presented what we felt were the solutions. The feedback we received, we were able to further refine. And we came up with the Administration of Criminal Justice Law of 2022. And if time permits, I will certainly like to give some insights as to how that law has been operating so far. But I think from our standpoint, we wanted to ensure that whatever solution we proposed was actually dealing with the problems that were on the ground. We didn't want to solve for factor A, when factor B was the significant contributor of delays in the system. So that's the approach we took it from.
Thank you. Okay, thank you very much for your initial perspectives. I'll come back to you on some of the details that I think that we need to drill down for us to be able to see how effective the additional criminal justice laws have been at the state level in trying to deal with the problem of trial delays. Let's go to Dr. Agomo. You are a reform enthusiast. You have done a lot of work in this area. Particularly, I would like to hear your views regarding case management. The Additional Criminal Justice Act, for instance, contains some very novel provisions that, if leveraged upon, would actually deal with some of the concerns we have regarding trial delays. The question has been that the courts are not making effective use of case management. What, in your opinion, do you think is responsible for this apparent lack of effective use of the case management provisions under the Additional Criminal Justice Act?
Thank you very much, Mr. Chair. All protocols duly observed, and I must say, please just permit me to deviate a little bit. Yesterday, by the time the Honorable Attorney General and Minister of Justice was leaving that late, I felt very touched, and I just want to commend him. I don't see him around. I don't know whether he's still around, but please, I just really feel that when we see something look like it's being gotten right, we should acknowledge. So out of my half a minute, can we really appreciate the Honorable Attorney General of the Federation? Those that know me know that I don't actually like that kind of clap. I'm kind of an enthusiast in terms of a coordinated clap, and I'll just show you what it is. And if you can help me do that just once for the Attorney General, it goes this way. Another one. And the last one. Perhaps if we do it more often, we can get into the system of the importance of coordination. Yes, you asked a question about all of these timelines, case management. Is it the magic wand? And I would tell you, there is a benefit of having a case management system. But case management system alone won't solve the problem. I recall some years back, we had a project that was actually supported by the Justice for All program. And we tried to look at, actually the title of that program was Speeding Up Justice System. And we did certain things. So we wanted to find out what was happening. And we clearly understood that there was a need to ensure, number one, that investigation is diligently carried out. So effective investigation, so that by the time the kind of evidence you have will be such that it will enable you not even to delay, to run and have that matter taken up and being addressed. And number two, the importance of diligent prosecution. That is a big problem. Number three, the notion about how speedy the trial process, goes. And I heard some comment also made regarding in terms of court not sitting. Number three, or four, what happens in terms of the quality of legal services that are provided for those who are being brought before the court. Number five had to do with the issue regarding transportation of defendants to court, transportation of people who are in custody to court. The last one had to do with witnesses. And I must tell you that what we saw, that this is a system. Can I say it again? It is a system. Our main problem, and this is my first key point here, is our failure to understand that as a system, we must continually be intentional in terms of how we connect the dots. We are not doing that enough. So even if the case management system works very well, and by the way, we try to introduce case management system at the police stage, at the Ministry of Justice stage, and with the two pilots, they had a pilot in Enugu, and there was an attempt done in FCT. At the court stage, at the correctional service stage, and I will tell you, some of them didn't work well, some worked well. Later, if I have time, I will delve into some of the problems. But let me quickly, so please, just a second, I'll just quickly mention this to say, apart from that basically point, so this issue about not forming the system, the other point I want to make here, there are 2 points quickly, and I'll keep quiet because I hope that more questions will come to me. The other point is, apart from being clear about the how system work, is the fact that there are 2 major things that controls the number of persons who are in custody, because you know that the custody population is a barometer to see how you have been functioning all through. The 2 factors is the rate of reception into custodial centers and the duration in custody. We are not watching it. And until we deal with those 2 parts, we can't finish it up. And my final point at this stage is our obsession. The word is obsession with custody. I hope I will have time to deconstruct what I mean by that, because there is truly an obsession with keeping people in custodial sentences rather than non-custodial sentences, even when that will work better.
Thank you, Dr. Agumo. I turn to you, Fernandez Marcos Obiene. You are the MBA SBL chair on technology law. And I know that for over a long period of time, you have been a major player in the tech sector, particularly when it relates to how to leverage law in the tech sector. Now, I would like to ask you, from your vantage position, what do you think we can do in terms of leveraging technology to reduce trial delays in Nigeria?
Okay, so this is part of the problem with technology sometimes. Thank you all very much. Thank you for the question. I appreciate the organizers for putting me on this panel and all protocols duly observed. If you allow me to talk about how we can use technology, I mean, I'll spend maybe 3-4 hours now. I will not finish. I have a book, by the way, that Professor Zana wrote before. Sorry, Justice Zana, Justice Zana wrote the foreword for. On how, and a lot of it talks about how you can use technology for the process of law. But I'm going to try and restrict my statements to the things that we discussed in our sessions prior to this. And there are 2 primary things that we discussed. The first one is verbatim recordings. I read a book not too long ago by Dele Ogun, and he was referring to an arbitration session from like 20 years before, and that they had a conversation, and that after the session, they would go through, there was already a script, they would go through and look at it and say, okay, no, this is not what I said, change this, not to minor extent. And then just after that, they could take those documents, and that was a record of the proceedings already. That was more than 20 years ago. And we're here today. In this session too, we have ad hoc, but a verbatim recording of the session. But we don't have that in our courts. What that means is that when somebody is doing examination or cross-examination, Rotimi Oyedepo SAN was telling me about doing cross-examination of one person for 3 months. And this is not supposed to be so, because a lot of the time, the work that we do really, we spend much of the time. And now we have technology available, different ones. I don't want to mention names, but there are too many that you can either record and upload, and they will summarize for you, or different things. And we have those, and we have them available. So that's very important. Now, that's a very important point. Now, in the course of our discussions, in one of the pre-summit sessions we had discussed that what we needed to do was to either make it mandatory for courts to provide verbatim recording, or allow people, the individuals who are in court, wherever the parties are, to do these recordings by themselves and then come to court for certification. So that eases, in my opinion, a lot of the stress. I mean, I understand that if the person who is a party who makes the recording, it doesn't necessarily ease in the sense that if the court is still writing down, it will still delay the trial, but at least he will make records available to him in almost real time. So that is one. And in our sessions, I think we all generally agreed about this. The second issue was virtual hearings. I know that we're doing this, selectively, but we're doing it quite a bit. Thanks to COVID. Before COVID, we had discussed it. My impression really is, and I know that a lot of people will not agree from this in this room, but my impression really is that in a few years, several years from now, we will have judges who don't have to sit in courts, who don't have courts. A lot of people will say no, but that's the reality. You have judges who don't need courts because you have these things readily available. And fortunately, we have them everywhere. We're using Zoom here. There are different other platforms, go to meetings, etc. Now, the problem with it is that while it is currently being used, there is the worry that somebody, we all know what happened in the OGU's Okalo matter, that after the matter had, they had successfully concluded the matter, went all the way to the Supreme Court, and then there was a reasonable argument that was made to the court, and the court held that the proceedings were invalid or were void. So it's quite possible that when the matter, maybe there's some argument that goes to the Supreme Court already today, and then the justices agree with the arguments and then decide that, all the work that you have been doing, a lot of all the things that we've been doing are not good. So we had proposed that there should be an amendment to validate all such proceedings so as to avoid such cases. So that's one of the proposals that have been made and that the NBA had made and that we all agreed to. There are a few other things, but I think I'll hold on for now so that the other panelists can speak. Thank you.
Thank you very much. So we take the issue of verbatim recording from that. You think it's very helpful. We also take the issue of finding some constitutional validity for virtual hearing, which probably doesn't really expressly, is not expressly available at the moment. So those are some of the very important things I can take from that. Bozimo, please, I would like to go back to you. I know you are a chartered arbitrator, and I know that there's been a lot of discussion on the role of the court in the arbitral process. Many practitioners have the view, particularly arbitrators have the view that the role of the courts in the arbitral process itself is one way that engenders a delay in the system. Now, as an arbitrator, what do you think is the intersection between the courts and the arbitral process? And perhaps you may also address the proposal on the table as to whether the original jurisdiction of the Court of Appeal should be increased to include dealing with issues of setting aside arbitral awards. Thank you.
Thank you very much. I know the constitutional question is going to be a controversial one, but let me start with the interface between arbitration and the courts. And I recall during his initial interventions yesterday, the Honorable Attorney General of the Federation, in stating the need to reposition the justice system, stressed the importance of positioning Nigeria as a viable arbitral seat, not only within the West African region, but within Africa as a whole, and eventually worldwide. And that's a key consideration to follow because, as we all know, the AFCFTA will soon kick in. And with that, we're likely to see an increase in cross-border trade and therefore an increase in cross-border disputes. Now, the problem you have in terms of cross-border disputes going to the courts is that let's say a Nigerian business is doing business with a Malawian counterpart, and a dispute arises from their contract. The Nigerian will not want to go to Malawi. Likewise, the Malawi person will not want to come to Nigeria. So they find arbitration as a good middle ground to resolve the dispute between them. Now, the value they see in arbitration are, aside from the efficiency, are the enforceability of that award. In fact, if you look at data from the Quimera International Arbitration Survey, it tells us that the most valued aspects of international arbitration are the enforceability of arbitration awards, the enforceability of arbitration agreements, and judicial non-intervention. And that's a bit of a paradox because on the one hand, we're saying judicial non-intervention is a valued feature of arbitration, yet we need the courts for arbitration to work. The problem I see is not so much that judicial intervention per se is a problem, but judicial intervention in terms of enforcement and challenge is becoming a problem. The enforcement rates themselves are quite high. So if you look at data, you will see that depending on whether it's a domestic or an international award, either 85% of awards will be enforced. And in international awards, because there have been fewer of them, it's actually a higher percentage. But the problem is the time it takes to enforce or challenge those awards. So on average, in the High Court, it will take you 1 year and 9 months. In the Court of Appeal, it will take you 2 years and 8 months. And in the Supreme Court, it will take upwards of 4 years on average. It could be longer than that. So if you spend, let's say, 18 months before an arbitration tribunal, you get an award, you can spend realistically from High Court to Supreme Court up to 9-10 years trying to either enforce or challenge the award. So the benefit you have gained in the arbitral process is lost during the court intervention process, hence the need to put some solutions on the table. Well, during the drafting of the Arbitration and Mediation Act, there were a few solutions that were put on the table, one of which was the drafting of arbitration proceedings rules. The arbitration proceedings rules are in the third schedule of the Act now, and what that sought to do was to streamline any arbitration-related application that comes before the court. So it sets a timeline within which the case must be set down for hearing, within which a response must be delivered, and within which the outcome of that application ought to be determined. And the question then came up as to whether those rules in and of themselves in an act of the National Assembly were enforceable, or do you need constitutional backing for it to be enforceable? I can tell you that a conversation is currently going on with the National Judicial Institute and with the Honorable the Chief Justice of Nigeria, similar to what the Honorable Justice Onogan did in 2017 when he brought out practice directions on commencing litigation in breach of an arbitration agreement. We want to see if it's possible for the Honorable the Chief Justice to give practice directions regarding the determination period for arbitration-related matters. But to your question, would it then solve the problem by eliminating one stage of the challenge or enforcement process, that is removing the High Court stage and going directly to the Court of Appeal? It's a controversial one because on the one hand, the argument against it would be to say, well, you are taking away the capacity to build jurisprudence at the High Court level, which is valuable for positioning Nigeria as a viable arbitration seat. On the other hand, you're saying, well, by removing the High Court level, you are saving, on average, 1 year, 9 months in the enforcement process. But that still leaves the duration at the Court of Appeal period. There still has to be an efficiency at that level to ensure that the purpose for which we are removing one level of scrutiny is still viable. And there might still be a further appeal to the Supreme Court. I know there is a proposed amendment in terms of limiting further appeals from the Court of Appeal to the Supreme Court, and perhaps we'll get a chance to discuss that. But for me, whether would it be viable? And it goes back to what Tunde Fagbonlu said earlier. It's not so much a question of the law and the framework. It's more a question of the application of that law. I think you can have a very viable system for three appeal levels if they can move very quickly. But insofar as we have inefficiencies in our system, I can see the value of saying remove one level of scrutiny. In fact, I believe it's what is done in at the Paris Court of Appeal, which has original jurisdiction to hear challenge and enforcement proceedings in France. So let me pause for now, but I hope the chance will come up for further discussion on this.
Thank you very much. At least you've identified the fact that eliminating one level could be helpful, particularly if we are able to put in place a mechanism that will ensure that from the Court of Appeal up to the Supreme Court level, there's some level of increased efficiency in the process, as it were. Fagbonlu, I'll turn back to you. You had talked about what would I call the virtues of the Administration of Civil Justice law. Can you just give us some major highlights of that law that you think can commend itself to other states who have not actually adopted this same legislation? Just major highlights only. And while you're at that, I would like you to consider the proposal on the table as to whether we should actually eliminate the pre-action notice in our civil justice system. Thank you.
Yes, but let me just clarify that pre-action notice being the requirements in statute, right?
Yeah.
For pre-action notices. Okay.
Yeah, yes.
All right. Maybe I should take that very quickly. First of all, the pre-action notice system, it's something that stems from public law. Many people would remember that in judicial review provisions, you have provisions to protect public law institutions, public institutions. And that's because the law recognizes that the decisions they make don't affect only private interests. They affect the public at large. And so if their decisions are to be challenged, certain protections are built in. You should let them know in advance that you intend to take suit. You intend to challenge this decision, just so that they can give consideration to whether there are alternatives that they can use. I am not yet convinced that that protection for public institutions needs to be removed, right? There's a different kind of pre-action system that we call pre-action protocols that have found their way into the rules of court. I think they serve their purpose, and I think those should be retained. But the protection for public institutions in the form of pre-action notices, I think they serve their utility. What I think is important is ensuring that those notices don't preclude people from getting interim urgent relief in cases that are deserving. So that's where I'll leave that. Going back to the administration of civil justice law, the bill rather, again, I will go back to the 3 points I highlighted earlier. Laxity, right? Now, this bill on a mandatory basis has certain provisions. For instance, one of the provisions is section 6.2 that says that in giving effect to the overarching purpose of the bill, a court to which this act applies shall at all times conduct its proceedings with the aim that the business scheduled for the day is accomplished. Now, if this were faithfully implemented, if all parties to actions knew that this case is scheduled for this purpose on this day, and nothing is going to change that, then they will adjust themselves accordingly. But our culture today, I've had a lawyer say to me, don't worry, I will adjourn it by writing a letter. That is reflective of our laxity. That is just exactly how serious we take the litigation process. If people knew that it is irrevocable and it is intractable, the business for which the case is scheduled will take place, then they will adjust themselves accordingly. And if judges had the mandatory responsibility to ensure that that happens, then I think we'd see more of a business-like approach to litigation. How about the court not sitting syndrome? Section 51F4 says that where a party's failure to meet a deadline is caused by an act or omission of the court, then the judge shall cause an inquiry to be made as to the circumstances of the act or omission and must make a note of such circumstances in the revised procedural timetable as the case may be, and as the case may be in the court's decision on an application for extension of time. What this essentially means is that courts will know, judges will know that they can't simply just send out a note that court is not sitting. There will have to be some form of accountability. It has to be recorded. An inquiry has to be done. So why did the court not sit? Why did the court not sit? Right? Questions will be asked. It has to be recorded. It has to go into writing somewhere. Now, let me go straight on to some of the other, the one subject I'm so obsessed about, the abuse of ex parte orders. I know why I'm so obsessed with that subject, because the ex parte orders in the jurisdiction that I practice mostly, which is in Lagos, the availability, I almost make bold to say the commercial availability of ex parte orders, the commercial availability of ex parte orders has resulted in the proliferation of frivolous cases. If people knew, I once talked to a QC. I was representing a Nigerian party that had an action before that they wanted to file before the English court, and we were looking for a QC to represent us. And I was amazed. In the very first meeting with that QC, the QC said to us, "Sorry, you don't have a case. I can't take it." That's a filtration system. There's a system in which very strong ethics exist, where your lawyer will say to you, "I'm sorry, I can't take it because the case is not good." But we don't have that filtration system. Why don't we have that filtration system? Because orders are available commercially. So merits are irrelevant. Merits are not relevant. You can get into court if you want to. It doesn't matter what the merits of your case is or are, right? Now, with Section 58, and I'm sure the bill is in the packs for the delegates. Section 58 has very serious controls that will prevent the abuse of ex parte orders. One of them, is a requirement that every ex parte order will have an expiry date on it. Every ex parte order will have an expiry date on it. And there's nothing new in that. That's exactly what the Supreme Court said in Kotoya and CBN, except we don't have provisions to enforce it. And so you'll see judges grant ex parte orders and then not sit for 3 or 4 sessions after that while the ex parte order is pending. If an ex parte order had an expiry date, the judge will sit to hear an application for discharge.
Well,
I have more to say, but my chairman is telling me to keep quiet.
Because we really have to. We have
Yes,
this, like I said, this is one of the most important sessions we have, and there are a lot of things that we need to consider. So let me just still go back to you, since we are dealing with these issues of delays and everything.
Yes.
So what would you say about this proposal that we should limit the right of appeal to the Supreme Court to curb delays, congestion and abuse? And what will be your view on that?
I totally agree with it. I think the Supreme Court takes everything and anything and everything. Again, I will give an anecdote from one of my experiences. Again, it's an example from England. We had done a case. It was brought against us, and it was to set aside. It was to refuse enforcement of an award in England. And the High Court ruled in our favor. They went to the Court of Appeal. 3 justices of the Court of Appeal ruled in our favor. So they had to write, the other side had to write a 100-page petition to it used to be called the House of Lords in those days, to be allowed to come to the House of Lords to appeal. And in spite of all of that effort, a 100-page petition, they got their response in a letter in which they said, look, one judge, 4 judges, 1 High Court judge, 3 Courts of Appeal judges have said, you've got no case. What do you want to come and do here in the House of Lords? Sorry, your application is rejected. I think the Supreme Court takes on too many cases. I have no doubt in my mind about that. I think the real question is, what kind of filtration system should we employ? So number 1 is in articulating those types of cases that can go to the Supreme Court. I will not make any suggestions on that right now. But the other one is again, it is already there in the law that in many cases you have to obtain leave to go to the Supreme Court. Now, how do we operate that in practice? Leave is granted as a matter of course. Leave is there for the asking. If you opposed an application for leave, and I've done it once before the Supreme Court, and I was so heavily criticized that day for even daring to oppose an application for leave, even though I thought I had a good reason why they shouldn't be granted leave. So we need to take our filtration systems a lot more seriously. They are there for a reason. And fair hearing does not mean that those filtration systems should not work. In actual fact, the effective working of those filtration systems is what fair hearing is all about.
Thank you very much. Fernandez, I'll go back to you. Yesterday, the Senate President, while presenting his address to this summit, made some profound suggestions for reform. Now, one of the areas he talked about had to do with garnishee proceedings, and he was very, should I say, positive about the need to do away with the Attorney General's consent. I know you come from the Attorney General's chambers, but perhaps you may want to share your views on this. Thank you.
Okay, thank you very much. Thank you very much, Prof. But before I answer your question, I would just like to complete, to add to what Mr. Prof, I will call him Prof, Mr. Fagbonlu had said. I just want to bring it in the context of the proposals that the MBA had made in advance. Now, of course, that was shared to a number of the participants. There was a link that was shared at some point that you could look to see all the items that were there. One of the proposals, all the proposals that involved this, was that we should eliminate, so we should leave most of the other matters, we should take them away and only leave appeals in respect of the vacancy of the office of the president or vice president, governors, elections relating to those, and then other matters which the court is of the opinion that either relate to, is it public, what was the word now? Or sufficient public interest or national interests or something of significance of note that the Supreme Court needed to address. Now, those were what we decided, and those were with leave to the Supreme Court. The proposal was that we would have only 3 justices in chambers, in chambers decide that and then send it to you, and that's the end. In the course of conversations prior to this meeting, I had we thought that that could extend to other courts too. What we have now is a system where you want to file, you want to seek leave to appeal. I've given a judgment. I've said you cannot, this matter is against you. You come to me to ask for leave to appeal. I will deny your grant leave to appeal. Then you go to the Court of Appeal to seek leave to appeal. Then, you know, that process. And why do you come to me? Why do you have to come to me? Ideally, the person from whom leave ought to be obtained is the court you are applying to. I've already given my decision. I've become functions official. I don't know the idea. I don't understand. I think Honorable Justice Kanyip addressed this in our pre-session meetings. He doesn't see the need why you have to come back to the court that gave the decision to say, okay, can I appeal your decision? So that's one of the proposals that was initially made. Now back to the issue of Ganishi. So I have to be careful. I don't want to say something here. I'm our guy at the top will say another thing. So, my opinions are personal. And because not too long ago, I was in private practice myself, and I've always thought that the idea was crazy that, you know, the court ordinarily have to have jurisdiction unfettered, and then the court has given the decision, and then you take it to one person and say that person should give consent for you to enforce. It doesn't make any sense. We discussed this. I think was it Mr. Ote that raised it during one of our sessions, and we saw that there are some merits to that case, but not 100%. Interestingly, I had the conversation with Mr. Obani just before, and then he said, which is why the Senate president included it in his notes, because they were going to all try to say that thing should be taken away. And I thought it doesn't make sense to be taken away. We should find a way to find a middle ground. The middle ground, in my personal, very personal opinion, not the office of the Attorney General, but in my personal opinion, is that perhaps there should be some notice to the Attorney General. And the reason why this is important is that there are various ways that people could use to, you know, steal money from government or rob government. It's easy. You're a counsel in the civil litigation department of the ministry or any ministry, and you go to court. I have a frivolous matter. You don't file an appeal. Don't worry, we'll get judgment. And we get judgment and we use it. So the opportunity should be given to the attorney. Apart from that, because this is a national issue of national concern, you want the country to be able to budget for it. You want the country to be able to take certain steps. So if you, for example, there's a lawsuit and you garnish the entire money belonging to federal government, the government will not be able to move. The point of that note is to allow the Attorney General time to say, okay, we don't have so amount of money, we can pay so amount of time, let us pace the payment or whatever it is. And then, of course, when it gets to they had mentioned, the Senate President had mentioned that when it gets to the Supreme Court, that it should be final. I still think the same thing should apply. The Attorney General should have an opportunity to, make a point. But then I don't think it should be absolute. You shouldn't have to give leave for somebody to enforce. But that's strictly a personal opinion. Still on Ganeshi, and I see that Dr. Ajibade is looking at his wristwatch while I'm talking. Still on Ganeshi. A while ago, what's the word now? The Association of Bank Legal Advisors and Company Secretaries, ABLACs, had come to meet an association I belong to called CreedLawNet, now Justice in Commerce Network. And they were discussing, they thought it didn't make any sense that every time I want to file Ganeshi proceedings, I'll just take all the 20 banks or now the other banks, and all of us will go to court and we'll be filing, notice. And I know this affects a lot of lawyers because there are some firms or there are some counsel that is what they rely on. They have like 20, 30, 40 Ganeshi proceedings because, people just bring banks. But it's not commercially viable in the sense that, I'm paying somebody to go to court to represent me when I don't have money. So how can we find some sort of middle ground? Again, we understand that in Nigerian context, there's very little record. And I know that Mr. Bozimo is going to talk about records. Please allow him to talk about records. Mr. Bozimo is going to talk about the effects of record taking and taking information, data rather. But then I know that we don't have enough data to be able to say this person has bank in A, or this person has account in A bank. But what we can do, what we thought of a means. So if you have an ATM card today and you go to a UBA ATM machine, if you have an ATM card from Zenith Bank and you go to a UBA ATM machine and you put it in, it will tell you you can check your account balance, you can withdraw that amount, which means that there is a process that you don't have to get everybody involved. There's a process you can do it. Fortunately, the Nigerian Interbank Settlement Systems Limited, or ZPLC, provides that technology. So we thought we called them to a meeting and we asked them, at some point. So if there's an order of court saying you should disclose if this person has an account in so bank, can that work? He said yes. So then we decided to have one of two procedures. Either we have a part of the courts where these people, a sort of a help desk in the court where you need to do garnishee proceedings. You go to that place with the order of court, you find out whether the person or not has a bank or an account in any bank, and then you go specifically to that bank as opposed to, going to all the banks in Nigeria. That's the first one. The second one is even if there's no help desk, the court can actually issue an order on NIPS to say, okay, provide information as to whether this person has a bank, and that removes that procedure for getting 20, 30, 40 banks. We even develop practice directions, which is in the bundle that we had circulated. And I hope that because chief judges in this place and chief justices are able to look at those and refine them as appropriate so that we can use them for the courts, for our courts. Thank you very much.
I can understand your expressing your personal views on this, but I guess you've made the point that we need to know regarding the role of the Office of the Attorney General in the garnishee proceedings. Bozimo, I would like to ask you two quick questions because of time. The first one has to do with jurisdictional challenges that do cause delays as a result of filing cases before courts of coordinate jurisdiction, but then they are not really the subject matter. It's not one within the jurisdiction of the court. Oftentimes, the matters are struck out or whatever, and it does create some delay in the system. How there's a proposal around the table that in cases of such nature, that there should be a transfer between superior courts of coordinate jurisdiction so as to eliminate the delay caused by jurisdictional challenges, particularly that may have some effect on the Constitution, really, particularly maybe Section 286A. Also, the other question has to do with the issue of part hard cases where judges have been elevated, and there's a need for them to come back to conclude the part hard cases. For now, we also have problems with that. And so the proposal around the table is whether we can have some constitutional dispensation that allows this to happen, where judges are elevated and they can come back and conclude the part hard cases quickly. Thank you.
Yeah, thank you very much indeed. On the issue of transfer, I think it's a very sensible proposal. I recall there's a provision in the Federal High Court Act that allows for the transfer of cases wrongly filed in the Federal High Court to the state high courts and vice versa, from the state high courts to the federal high courts. And recall, I believe it was a Court of Appeal decision where there was a case wrongly filed in the Federal High Court, in the state high court. And the council wanted to rely on that provision in the Federal High Court Act to transfer it to the Federal High Court. And the response was that, well, the Federal High Court Act cannot govern practice and procedure before the state high court, and therefore I'm going to strike it out. So that to me was procedural inefficiency. I think it makes a lot of sense. I personally think that a statute is binding on the courts that are operating it, so that they ought to have transferred to the Federal High Court in the first place. But if it takes a constitutional provision to make that point clear, I think it is efficient to do so. And I say so because we have very many things that add to courtroom inefficiency. In fact, I recall a conversation, I think it was with Dr. Ajibade, I was having that conversation with, and he said that the problem we have is not quite access to justice, it's actually exit from justice. You get into the courts, and it will take you a good number of years to come out. The primary example I like to give is the decision between Shell and Anaro, which is now reported as a Supreme Court decision that my father started in 1981 when I was just born. And I argued the case in 2015 in the Supreme Court. And by the time the Supreme Court gave its decision, 75% of the plaintiffs were dead. The value of the Naira had depleted by almost 80%. So the judgment they obtained of 50 million Naira or so in 1991, by the time it was 2015, had minimal value, even with interest. So they couldn't enjoy that. So I see great value in that. Likewise, for procedural efficiency, again, a constitutional provision that allows a judge to come and determine a matter that has been part heard I think these, I know we're very limited on time. That's why I'm rushing through some of these points. I see the efficiency point in making that. And the point we need to ensure is that if we can make little gains, if we get a 5% gain here, get a 10% gain here, we can aggregate marginal gains. So what would ordinarily be a very long and inefficient procedure, we start seeing efficiencies and economies of scale.
Thank you very much. Thank you very much. We've actually considered a number of issues, and because we are almost out of time, I would want to quickly just highlight some of the things that we have agreed or discussed, and for us to have at the back of our mind, so that when we are conducting the question and answer session, it will help us in and look at the issues more closely. The first is that we have discussed the possibility of eliminating the requirement of pre-action notices as a condition precedent for legal actions against government agencies, particularly where we have raised this in the context of Section 6 of the Constitution, and to see whether courts really can be empowered in that regard, having regard to the constitutional provisions and the power of adjudication provided under Section 6 of the Constitution. We've also discussed the utility of having some form of constitutional validity on remote, or if you like, virtual court hearings in the light of the provisions of Section 36 of the Constitution, and perhaps the somewhat loose system we have at the moment, despite the express directives of the NJC in that regard. We also have looked at guaranteeing litigants' right to obtain a verbatim record of court proceedings as an intrinsic part of the constitutional right to fair hearing, again, looking at this in the context of Section 36 of the Constitution. We also have looked at the possibility of limiting the right of appeal to the Supreme Court to curb delays, congestion, and abuses, and to ensure the Supreme Court serves its purpose, its proper function as a policy court, only deciding cases that raise issues of, substance or that are important, as it were. Yes, we can come. Have looked at the possibility of having constitutional provision validating statutory provisions that limit grounds on which arbitral awards can be challenged, as well as provisions that limit the powers of a court to stay proceedings pending determination of interlocutory appeals. Again, we are looking at this in the context of Section 286B of the Constitution. I think another issue that has been discussed is a possibility of providing for the transfer of cases between superior courts of coordinate jurisdiction to eliminate incessant delay caused by jurisdictional challenges in these courts, again, in the institution. And then the issue of granting compensation for elevated judges to return to their previous courts to conclude hard cases, again, in the context of Section 294 of the Constitution. And finally, we are based on the experiences so far with the Administration of Criminal Justice, Administration of Civil Justice Law, that is giving its very commendable provisions, whether states should not be, or whether we should commend it to states for adoption, so that they can also have that system in place to ensure that there's elimination of trial delays in the criminal justice system. So, gentlemen, thank you very much for the time. Like I said, there are so many issues, but the time is not on our side, so we had to rush through many of these. But I would like to thank our panelists, Dr. Agomo, yeah, I guess, Professor Fabulu, SN, Isaiah Bozimo, SN, and my brother Fernandez Marcos Obiene, for your very kind thoughts on the subject. I thank you very much for your time. Thank you. May I yield to the next panel, please? I will have to wait here because there may be questions on some of the issues that we made. Yeah. No, yes, we will. So may I respectfully yield to the next panel? Thank you very much. Mm-hmm.
Thank you very much. My lords, learned senior advocates, the Honorable Attorney General. Our panel is to discuss discipline at the bar and bench, the case for enhanced disciplinary powers, performance management, and court monitoring. We are really very grateful to the Honorable Attorney General for including the bar or the legal profession as part of the consideration for reform in the justice policy. There is a saying that the future is more important than the past. A canoeist who hopes to make progress faces forward, not backwards. And Honorable Justice Salami was with us at the Hallmark of Labor event last week, where we were told that Genghis Khan successfully breached the Chinese Great Wall by bribing a messenger to open a gate for him. This gave him the ability to move his soldiers past the wall, eventually reaching and attacking the capital, Beijing, paving the way for a broader conquest of China. This led to the overthrow of the Jin dynasty and installation of the Yuan dynasty. We have spent these last 2 days trying to build walls, to change our constitution, to improve the administration of the courts of justice. Now, at this panel, we ask ourselves, who will look after this wall? Who is going to look after the wall that we are trying to build? We know that the lawyers are the bulk of those that will look after this wall we're trying to build. So we have raised certain interrogatories that we'll discuss on this panel. Why should we build a system that can be easily destroyed through lack of discipline, ethics, and professional responsibility? We ask ourselves the other question: how can we improve the skill, knowledge, competence, ethics, and professional responsibility of those coming into the justice delivery system? We ask the question again: what is the situation on the ground now? From current monitoring effort in terms of where we are, in terms of our justice delivery system. We ask ourselves the question, do we need to change? What is the rationale for change? If we don't change, what will happen? Those are about the questions that we'll be asking ourselves on this our panel. So to discuss these issues, we would have Hadiza Usman, who has been involved with court monitoring and intervention with an objective to overcome the obstacles in justice delivery. She will share her experience and findings on perception of formal justice delivery by the masses from her legal and civil society perspective. And this will provide us the background for other interventions on how we can better regulate the professionals in the justice delivery sector. Professor Akinseye George, Senior Advocate of Nigeria, has both academia and civil service background. And he will give us an insight on how we could improve the quality of those entering into the legal profession, and by default, the bench. We have also Honorable Justice Olushola Williams, retired, who has been consulting in the area of performance measuring and has been working with the bench as well as the paralegal industry. She will be speaking to us on how we can improve, measure, and discipline those who have come into the system. So whilst Professor Akinseye George will talk about those who will bring into the system, but once they get into the system, how we can maintain the standards. And lastly, we have the privilege of having Honorable Justice Mohammed Garba of the Supreme Court. We have given him a wild card. So he has a carte blanche to speak to us on any of the issues that we have discussed. I myself, I will deal with only one aspect of those interrogatories that I have raised, which is the rationale for change. Why must we embrace change? And the first issue I want to draw your attention to is the IBA, International Bar Association Review of Global Practice. And they identify that there are certain factors that are driving change in legal practice. You would have noticed from many of the presentations, whether our mostly the foreign presenters and our keynote speaker, Honorable Justice Mutunga from Kenya, that these forces are there, whether you want to believe it or not. One, changing demographics and values. You know, there's a lot of emphasis when our keynote speaker spoke that we should develop an African jurisprudence. Skills mismatch and legal education reform. The clients are asking for many things that lawyers were producing today don't have the skill to deliver on. And usually, if they don't have the skill, they go for shortcut. And what does that mean? Indiscipline and corruption. So there's a global shift in economic power. You see shifts that are going on, mostly towards Asia, like China getting more powerful. But now with the pandemic, there's an attempt to move and shift, and that shift is coming towards Africa. You have the African Continental Free Trade Agreement and other factors that are moving business towards Africa. Emergence of new forms of value creation, Just let me summarize it. Uberization of legal services, where people want to use technology to give the services, and that's competing with us. There are also other professionals competing with us, whether it's accountants, etc., who can deliver the services that we are delivering. And of course, you know that there is also Bakassi Boys and OPC and the rest who do dispute resolution, whether you like it or not. Then there's technology. We've been talking about technology, legal technology as a driver for change. And of course, the regulation, which is what we are trying to discuss here. So let me just summarize some of these issues. It didn't start today, but the argument has always been there for a long time as to what is the role of the court. And there's an argument in Parliament in 1849 in Canada, where they said that the cause of all misgovernment in any country is the maladministration of the laws in the courts of justice. So the only reason why there's a misgovernment is because the court itself is not properly run. And then, so if that argument is correct, then if lawyers are therefore basting against misgovernment, what competencies and ethical standards prevent maladministration of the courts? So we have a duty to prevent maladministration of the courts so that we can then be in a position to prevent misgovernment. And there are many arguments about whether you even need lawyers for the purpose of justice delivery. Some people say you don't need lawyers. People can argue their cases directly. Why do you need lawyers? And then have these layers of courts, area court, magistrate court, high court, court of appeal, Supreme Court, and you're arguing whether some cases should stop at court of appeal and not go to Supreme Court. Why? It could be cheaper for people to argue their cases themselves, and it could even be very populist, you know? So, and remember, I give you an example. In Ghana, during the Rawlings Revolution, all courts were disbanded, and then all the lawyers' books were burnt. The lawyers and the court systems were blamed for maladministration in Ghana, our next door neighbor, almost. And citizens' tribunals were set up to administer justice. It took 10 years before the profession came back in Ghana. We have the warning signs in Nigeria. If we do not drive reform, it may come from outside and it will be disastrous. I refer to what is called enlightened self-interest. It's in our own.
Hello. Hello.
Hello. Hello. Thank you very much. Thank you very much, Leonard Silk. Please permit me to stand on the already established protocol. I'd like to sincerely appreciate the organizers of this event for giving me this opportunity to be part of this panel, to have a discussion from our end, that's from civil society, on what we're seeing in the field as we're engaging with the citizens. Because as I've been listening to the conversations that have been taking place over the course of these 2 days, I noticed that we're not referring so much as to the challenges being experienced by the citizens due to the challenges within our justice system. And it's amazing that other stakeholders, other justice sector actors too, have not been carried along in the conversation. Just to say, I work for the Rule of Law and Empowerment Initiative. We're also called Partners West Africa, Nigeria, P1. And we work through 2 program areas, rule of law and citizen security. Based on our rule of law program area, we've been able to engage with justice sector actors across several states. And that engagement led us to commence court observation or court monitoring, as it's popularly called, in 2016. And through that process of court monitoring, what we did was we tried to understand from the citizens' perspective of our justice system. We deployed citizen observers to several courts in the FCT, in Lagos and in Ondo State, to try and see these challenges that we've been discussing for the past 2 days from their own view, and to try and understand who within the justice system, which of the actors was responsible for what, and what could be done to improve the system. So through the collaboration we've been having with the judiciary, we've been able to find a lot of results, most of which have been discussed here. For instance, congested dockets, we know that. I think from our findings, each judge has about 10 to 15 cases on their course list on a daily basis. So of course, sometimes they are not able to attend to all those cases. The issue of adjournment has been discussed again here. Several adjournments, not only at the instance of the court, of course, but other parties' requests for these adjournments, the defenders, the prosecutors, whether or not they're ready for trial to go on. We've also noticed that the absence of witnesses during the trial process also causes such delays. Of course, we know in some of the cases, investigations are still ongoing, and so such cases will not go on. And these and so much more are the reasons for the prolonged trials that we're seeing. So why did we decide to do this court monitoring, other than in order for us to sensitize the public about the challenges within the justice system and show them the reasons why trials are being prolonged? We wanted increased social accountability. In order for us to have like a functional justice system that is accountable to the citizens, we decided to embark on this court monitoring process. For adequate change to be made, and what cannot be overemphasized is data collection. Within the justice system, we work a lot on a lot of cases, several issues. We're collecting data on a daily basis, but no one has an accurate record of that data. Or if someone has that, it's not sharing it. There's no widespread knowledge about the data coming in through our justice system on a daily basis. And that proves to be very challenging. For you to be able to have support, for you to be able to have stakeholders willing to support the system, you need to have accurate data to supply, to show the reasons for the challenges you're experiencing, the areas you need support and enhancements. So we also use the data collected for policy influencing. We release these findings to the judiciary and other key stakeholders in order to show them the areas we've identified that is leading to challenges to access to justice and all other identified issues here. So one of the things we've been able to do through this court monitoring that we can equate to monitoring and evaluation, for instance, in Ondo State, by the time we commenced the court monitoring in Ondo State, the then Chief Judge of Ondo State, Honorable Justice Akeredolu, actually used the data from our court monitoring as a performance evaluation for the magistrates in that state. So it was very important for those magistrates that we were observing to ensure that they followed the rules as they were and the laws. detention until Monday. So we say go on Monday, and these issues are still ongoing. But what we've seen. Okay. Yes. But what we've seen is that with these duty solicitors in those police stations, we're able to give police advice even over the weekend. We're there when statements are being taken, we endorse them and ensure that all the rudiments that they need to draft proper charges is done, and that they send off the case files for legal advice. So we're seeing increased adherence to the provisions of human rights and respect for the rights of the detainees. So what we're seeing now in the field while working with the citizens is that there's a growing reliance on our informal justice sector, like we call it in civil society. So our citizens no longer want to come to the formal justice sector. They do not want to come to our courts. They do not want to go to the police stations. And now they're relying heavily on decisions from the traditional leaders, the religious leaders, who are mediating on several cases rather than the cases being brought through the formal sector. What we've done is to bridge that gap. So we have mixed observer teams across several states. And what they've been trying to do is try to bridge that gap between the formal and informal, work with these traditional leaders for those cases identified to refer the cases to the proper channel for the proper decision or proper or responsible agency or institution saddled with the responsibility to take it up. Not only do we do that, but we also work with lawyers to ensure that cases are taken to court and addressed. There's also a huge lack of confidence and trust by the populace in our justice system and security agencies for several reasons, some of which have been highlighted here. Most of the citizens believe that if they were to go to court, they won't get justice. What we've been trying to do is have conversations to them on what their own perception of justice is. So we within this space, our perception of justice and justice in the community is very different. So there are some cases that ideally should be heard and mediated upon at community level, and some escalated as the need may be. We're also seeing that within this system, there's really poor interagency coordination from end to end. So be it from the police to the Ministry of Justice to the courts and to the correctionals. Several prison decongestion exercises have taken place. I've been there for a couple of them, and what we've seen is that there are a lot of inmates that are remanded in custody with no case files. And then, of course, I'm sure most of the chief judges here have met that on one or two occasions where you're all there for that prison decongestion exercise and an inmate or a detainee is brought before you and you ask the Ministry of Justice, where's the case file? They'll say they don't have an idea about this detainee, and ongoing, everybody within the justice chain does not have that information. So there's also, of course, lack of transparency and accountability. Little to no knowledge is known about the working within the justice system itself. So, of course, questions are asked and answers are not gotten, both from our oversight institutions who have the responsibilities to give us these answers, and those responsible not taking proactive steps to engage with members of the community. So I have mentioned that not only do our oversight institutions have that responsibility to discharge their duties, but we as citizens also have that mandate upon us to hold our justice sector actors accountable for their services. I've listed several recommendations that I believe will help. Investing in technology, it's been mentioned before, and I'd like to say that in the FCT, in Plateau, and several other states, there has been provision of technological support to several judges. This technology ensures that a speech-to-text feature is within it. Cases are recorded verbatim, and the judges are able to have that transcribed. Judgments are being issued in record time. I think I saw Honorable Justice Obano here yesterday. She's using that technology in her court, and there's a high turnover of cases from all those courts that are utilizing this technology, which is called the QSoft De Novo. That's the one that we have supported the installation across several courts. So what we're saying is we're trying to urge for widespread rollout of this technology across all the states to ensure that taking down proceedings by longhand by our judges is done away with, as that is one of the key reasons for prolonged trial. I've also mentioned here that interagency collaboration is key. We had reason to have several interagency coordination meetings where we brought all the justice actors on a monthly basis or quarterly basis to have conversations.
One minute.
Thank you, sir. I'm almost done. To have conversations on the issues that they were seeing. Is it because legal advice was not issued that certain cases were not going on? What exactly was causing the prolonged trials that we were recording? And as at the time we were having these meetings, there was drastic improvement within the system because they had the contacts of each person responsible and could call them to order when the need arises. I also recommended here that there should be an expansion of the court observation. From everything we've done, we were in less than 60 courtrooms across all the states. You can imagine if we have this court monitoring and observation across all states in all different courtrooms in Nigeria, so much information will be derived of these challenges we're highlighting. And not only will we have the information, but they will be data driven, and we can use that for advocacy to the key stakeholders in order to get support within the system that we need. Lastly, I also recommend that there should be a strong monitoring and evaluation system within our justice sector, because that will show us the targeted approach and strategies as is being discussed.
Thank you very much.
Thank you very much.
Thank you very much. Thank you for that excellent presentation. I would like to invite Professor Akinshayo George, Senior Advocate of Nigeria, to make his contribution.
Thank you. I'm a Lords. Senior members of the bar here present, distinguished ladies and gentlemen. Okay, I'm going to be speaking on legal education and the disciplinary system, whether legal education and the disciplinary system of the legal profession is fit for purpose, and whether we should not take some urgent actions to address some of the observed deficiencies in the system. Let me quickly acknowledge that there are some members of the audience who are more eligible than me to perform this role. Let me quickly acknowledge Chief Adegboyega Wumolo, SN, Chairman Body of Benchers, Chief Mrs. Funke Adekoya, and Mrs. Funke Adekoya, SN, and Professor Muhammad Tabiu, who is also here. These are personalities who have done a lot of work on this subject. Those of you who are familiar with my work in the last few years, since 2003, you would recognize that I've been working on administration of criminal justice. And I'm very happy, humbly, to say that I was one of those who championed the development and the passage of the Administration of Criminal Justice Act, which has now been replicated in all the states of the Federation. And this is why I'm confident that if we come together, if we work together, we are able to transform our justice system. I also believe that the future of this country, the future of the democracy of this country, depends on the legal profession. the legal profession controls exclusively a whole branch of government, the judiciary. Of course, we have support staff and all of that. But judges, legal practitioners, attorneys general, these are the major components. We constitute a whole branch of government. And in countries like India and some other countries, politicians will always be politicians. They will break the rules, they will fight, they will misbehave. There must be an institution that mandates and enforces integrity. And that is the judiciary, the legal profession, with the help of the legal profession. And that is why India, for example, notwithstanding so many challenges that they have, because the judiciary has stood strong, the legal profession in that country has stood strong, they have been able to stabilize democracy and then stabilize that society. I think we can do as well as that, if not better. Let me ask a question. I want to talk about legal education. How many of us in this room can tell me now, especially members of the Council of Legal Education, how many lawyers do we have in Nigeria? Tell me. We are supposed to be a profession. We are supposed to know the number of entrants into the profession. We are supposed to know how many lawyers Nigeria will need in the next 5 years, in the next 10 years. Who can give us that reliable data? I asked the members of the Council of Legal Education. Nobody seems to know. There are lawyers who are dead lawyers, living people practicing the name of dead lawyers. Oh, yes. Entry into the legal profession. The legal education is the fountain of the bar and the bench. Entry into the legal profession is uncoordinated. There's declining quality. We don't need to talk about that. Many of the lawyers we are turning out today are not fit for purpose. This is the root cause of many of the problems we are having. We are having lawyers who cannot express themselves in English language, who cannot write, who cannot complete cannot make a few sentences grammatically correct. Now, but why is that so? I have a paper. Let me just rush through it. Quickly, I'll jump a few points. Thank you. I said the strength of any legal profession depends on the quality of entrance. The leaders of the profession must therefore take greater interest in legal education. Legal education has three main objectives: impartation of knowledge, skills, and values. We don't impart skills. We don't impart values. We only impart knowledge. And then legal admission into law schools and law faculties is now politicized. State universities say every local government must have certain number of students. So qualification is no longer material. In the past, when we got into the university, it was clear that you had to have you must not go below this number before you can get into a law faculty. But is that still the case? There are private law schools now that have over 400 students in a single class. When the whole of law faculty a few years ago, a whole of faculty may not be more than 300. Private schools would admit many law students because law education attracts more money. I know of a private law faculty that has more than 500 students, law students in a single class. Nobody is talking about these things. NBA is not looking at these things. And yet we say we have a profession. Are we really preparing for the future of the legal profession? A few years ago, because of some of these concerns, some of us, Professor Ernest Ejukwu, my humble self, and Professor Akin Ibidapobe, we started what is called a network of university legal aid institutions, NULAI. Our objective was to reform legal education. And I'm happy to announce that the law school has adopted what is called clinical legal education as a means of training their students. Thank you. But the law faculties, because you can't begin to train a student in the law school, it's already too late.
The training ought to start from 100 level in the universities through clinical legal education. But the challenge we have is clinical legal education is marginalized. It's not mainstreamed. Older professors are stuck in the analog age. They say, you young boys, what are you talking about? Whereas the world has moved ahead. We are talking about clinical legal education that teaches knowledge, values, and skills that is needed by the market. We are advocating that there should be a Legal Education Reform Act which will mainstream value-based, student-centered, result-oriented learning, where a lecturer does not stand before students to dictate notes, but a lecturer interacts with the students, challenges them, makes them to apply themselves in real-life situations. Clinical legal education, we can go on and on, but let's leave it at that. Then we come to, now they have become lawyers. What is the process? How strong? What is the integrity of our disciplinary system at the bar? And now we have, how many cases do we have in LPDC? My research shows that we have about 1,000 cases pending, backlog of cases in the LPDC, legal practitioners, and we have just one panel. Because a judicial interpretation has said that there must be a quorum of all five members sitting at the same time. And in Kalejaye and Nwalutu, the Supreme Court said these five panels must sit consistently from the beginning to the end. Agreed. Why are we not able to have multiple panels? Multiple panels sitting. Why is it impossible? Because we have not shown interest in discipline at the bar. Lawyers file petitions every day. But these petitions, some petitions have been filed 5-6 years, hanging, no action. Then those whose cases went to the Supreme Court on appeal, because of the decision in Kalejaye and Nwalutu, they have now amended their notices of appeal to say that those panels that found us liable for infamous conduct was not properly constituted. Therefore, the directions are null and void. Of course, you know the outcome. So what message are we sending to the consumers? What message are we sending to the public, where lawyers who have defrauded members of the public have their appeals against decisions of the LPDC thrown out by the Supreme Court? What about referrals by judges? Judges sometimes in their judgments say that some lawyers have conducted themselves in an infamous manner. Nobody takes action on those references. Nobody. So why would lawyers not continue to be rude? Why would they not continue to misbehave, especially the younger ones that we are bringing up? Recently, we have had lawyers boxing themselves right in court. No action. We've had a lawyer celebrating his admission to the inner bar and then wearing the wig and dancing at a party where money is being sprayed. Now we have lawyers graduating with BSc law. Oh yes, this is what happened in an uncontrolled. We say we're a profession, but we're not controlling who enters the profession. We're not maintaining discipline. Can you have a profession without a disciplinary system? Is it possible? What you cannot count, you cannot monitor. We don't know who is in the profession. It's a maddening crowd. That's why at our bar conferences, you find all sorts of behavior. People fighting over materials for conference. I think we have reached a crisis stage, and we have to go back to the drawing board. Of course, maybe we can still catch a few we can still do something with the older ones, but let's start to target the lawyers who are still being formed from the universities, from the law schools. I conclude, when a petitioner abandons his petition in the LPDC, can the LPDC take that petition, even though the petitioner has abandoned the petition? Because we have always believed that a petition that goes to the LPDC is a petition that affects the integrity of the profession, not only of the lawyer that has misbehaved. Now, there's compromise between the petitioner and the respondent. the petition is abandoned. On the day set by the LPDC for adoption of petition, the complainant does not show up. LPDC goes ahead and says, we are going to give the lawyer an opportunity to clean his name. The secretary of the LPDC goes ahead and says, based on documentary evidence, this is the petition we received. And the LPDC takes an action. Counsel goes to the Supreme Court. Hearsay evidence. Because the complainant was not at the LPDC to adopt the petition. And Supreme Court said, yes, petition ruling, direction, null and void, because it was based on hearsay evidence. We have so many gaps, so many lapses, so many self-destructive tendencies within our profession. Yet, the society is looking up to us. The lawyer, they continue to go to court, notwithstanding the challenges that we have because of our past glory. I urge, distinguished ladies and gentlemen, my lords, that we need to take a serious look at legal education and at the disciplinary system at the bar so that we can rescue the profession. And then we can hand over to the future generation a profession that is more dignified and even probably better than the one that was handed over to us years ago. Thank you so much for your time.
Thank you, Prof. Thank you so much, Prof. I now invite the Honorable Justice Olushola Williams to make her contribution.
Good afternoon, my lords, Leonard Silks, distinguished ladies and gentlemen. I also rest on existing protocols, and I feel very privileged to be part of this gathering. Now, I have just a few points. I think there are majorly 3 or 4 of them, but I want to make a comment about the proposed alteration to the composition of the NJC. And my question has been, even with the proposal that we have that doesn't seem very popular, has that alteration even gone far enough? I don't think so. Should we not have members who represent the general populace, maybe recommended by the legislature? We had the Learned Attorney General of the Federation saying that there has to be checks and balances, and that is exactly what we need. And I'm strengthened in this view by the Kenyan example we were given yesterday. In the Kenyan example, there is public participation in the council that appoints judges. Parliament vets commissioners who represent the public. And I would just like to recommend that to us in the bill. Now, I'm going to talk about evaluation of performance and continuing legal education. Evaluation of judicial performance is a tool of judicial accountability. Judicial performance evaluation refers to the systematic survey and measurement of judicial performance. It is a tool meant to ensure that judicial officers and institutions achieve administrative efficiency and are properly held to account. It is valuable for judicial professional development, as amongst other things, it motivates judges to be more productive. It also helps the public to understand what judges do and how they perform. The global principles and best practices in evaluation of judges provide a foundation for designing and implementing effective evaluation mechanisms. Now, we all know that the NJC fulfills the role of evaluating judges and disciplining judges. Now, so the NJC has established a performance evaluation committee of judicial officers of superior courts for the purpose of assessing and monitoring the performance of judges. And the objectives of the committee are: 1, to provide adequate mechanism for enhancing the performance of judicial officers through continuous assessment, monitoring, evaluation with the aim of improving effective and efficient productivity in justice. 2, to aid continuous development of assessment tools and sources aimed at securing public trust. You know, when I had Mrs. Adekoya saying yesterday that practitioners know when the performance evaluation form is about to, be submitted and see how some judges react. I think one of the problems is that the performance evaluation we have now, and I'll still talk about it. Now, if a judge is able to get away with making up for lost time by just, doing some things, then we can see that that means that we are not having that continuous assessment that we ought to be having. So we have this evaluation form by which judges self-report on their performance every quarter. And upon the submission of the quarterly report, the committee considers them and decides which judges deserve commendation or which should be queried for performance. And these forms are meant to be accompanied by copies of decisions mentioned in them and submitted through heads of court. And we had Justice Kanyi talking about that. In my personal experience, I don't know if my head of court actually has read my judgments that I submitted. I find it very difficult to believe that it was done. And I do not blame the head of court, because how is he going to read the 10 decisions of each of 56 judges in Lagos State because he wants to submit them to the NJC? Is it practical? Is it achievable? Now, head of court are assessed based on the basis of the performance of judges in their description, in their jurisdiction. The committee also carries out periodic visits to various jurisdictions to explain the purpose and how to fill the forms, and for discussion on challenges judicial officers may be facing. However, the committee warns judicial officers that they must take responsibility for and personally fill the forms. A judicial officer will be sanctioned for appending his signature to an inaccurate report because there is no automated, independent, verifiable system of recording, which is what we need. The judge himself counts his cases. He himself tells his registrar, or between the two of them, they decide what are the cases that we have done. And then they put it in the form, and then the form gets sent to Abuja. So that is self-evaluation. Now, so in addition to the heavy mountain of judicial work, the judge has to take on this administrative task because his support staff is ill-equipped to understand the form or analyze the volume of work that has been done. At one of such visits, an erudite member of the committee stated that the quality or length of decisions did not matter, that judges will only be commended when they churn out decisions, not rulings, on contentious cases. The fact that the committee only sees the number of judgments delivered on contentious matters as proof of efficiency is underscored by its guidelines on its scoring or assessing of judicial officers. And the committee has advised judges of the following assessment quota per quarter. Because when Mrs. Adekoya was, when she made that comment yesterday, Justice Kanyi was saying, oh, it's not possible that a judge would rush some things and all that. Now, these are what we have. 0 to 3 judgments means in a quarter means no performance. 4 to 5 judgments means marginal performance. 6 to 11 judgments means fair performance in a quarter. 12 to 18 judgments means good performance. 19 to 23 judgments means very good performance. 24 or more judgments in a quarter, excellent performance. We have been talking about delay here. We've been talking about what is actually happening on ground. Is this realistic? Is any judge who is practicing in Lagos under, even anywhere, let's talk about Lagos. So we have all the help we say that we have, but we discussed all that is happening, can possibly, truly accomplish 24 judgments to be an excellent performer. So there are many disadvantages to the number crunching system of evaluation. The truth of the matter is that to be effective, performance evaluation must be broad-based. Metrics that are too narrow or focused will be easily manipulated, I will leave my observation as just that, rather than dwell on the way the forms have been manipulated, because I mean, it's very unsavory to talk about what has been done in order to try to accomplish, this number crunching. So apart from counting the number of cases concluded, motions decided, and cases assigned to a judge, the committee does not in any wise consider the legal knowledge of a judge or his comportment or case management techniques. Pinning the evaluation of judges to the number of cases they reportedly decided each quarter cannot give any empirical or objective indication of the performance of the judiciary, I beg to say. So the NJC must overhaul its judicial performance evaluation standards and mechanisms. The focus, for instance, could be on how many hours of work is done per day or year, not how many judgments are written. I would have thought the most important thing for the judiciary is disposal of cases. The most important thing is actual adjudication and speedy dispensation of justice. And those are the basis on which evaluation should be done. It's not necessarily the number of cases. Now, of course, Mr. Adeka was saying, oh, a judge would come and strike out the cases, But there are instances where, because, and I have to be really, unfortunately, very frank about this, because of this evaluation system, I have two parties before me who are ready and willing to enter into a consent judgment. But because I want to have 4 cases, I say no, at least you have to call a witness. You have to have a form of trial so that at the end of this quarter, I would have written a contentious judgment. It's happening. So does that accomplish speedy disposal of cases? No. Well, there's a lot, to be said about all this, but I think a lot of what we have realized in this summit is that we can make laws, we can make regulations. It is the political will and the persons that are actually administering them that is very important. And I think that is why one of the things that Professor said about who is entering into the legal profession to start with. And it also goes to who is being appointed to start with. And it also goes to who is monitoring the NJC, like somebody asked, who is monitoring the monitor? It's very important. So the NJC also must determine, because how you monitor judges should also depend on what resources are available to them. Now, we're talking about equality of justice. We're talking about equal access for all persons. But from what we have said today, somebody who is living in Gombe State cannot get the quality of justice that somebody living in Lagos State can get. Is that the Nigeria that we want? That is not the Nigeria. So what they proposed alteration by the proposal by the NBA of this separation of the administration of the court from the administration of justice is crucial. It must be done. And I think that we know that it must be done. We shouldn't dwell too much on who is appointing who, because there will be separation of power. The judiciary will appoint members. The executive will appoint members. In fact, the legislature should appoint, because legislature is supposed to be representing the public, the people. So where all these people can be represented on the board of that court administration body. So when Honorable Justice Dipolu queried whether chief judges know financial regulations, they will not need to. If they are facing administration of justice and not administration of courts, it will not be, very necessary. Now, the draft bill actually has proposed that the appointment should be through transparent and competitive appointment process of non-civil service chief executive officers. So I think that there can be proper provision on how that can be done. Now, a systematic way of monitoring courts. I actually Okay, before I go to that, another thing that is very important, because I talked about resources just now, another thing that we need to talk about when we are monitoring judges is the issue of welfare. And I question, because a lot of times I ask my colleagues, because I seem to be, the only one who doesn't know, or maybe because I retired early. But is there actually a clear-cut policy for judicial welfare? If there is it well known to the judicial officers that are meant to benefit from it? It is essential to create a policy that provides a structure and a clear process to be followed when ill health advice happens. What we have here is that we have judges who are ill and obviously cannot go on with the pressure, but they will never themselves voluntarily say, I cannot handle this. Why? Everybody's afraid of, okay, losing bread and butter, fine. But there's also the issue of, if I go and say, this is my health condition, what are the guarantees? What protection do I have? That, the whole world doesn't know about my situation. In fact, what am I going to, when I go and say that I have this health situation, what is going to follow from it? So the welfare, if we don't provide welfare, we cannot positively measure the performance of judges. recognizing this cadre of professionals, equipping them and regulating them. If the bar does not regulate them, it is still going to bite the bar back. We have people who they are supposed to be assistants. They are not assisting anything. They are not, they don't have any stake in the justice system. In the judiciary, if you report a supporting staff, the judiciary doesn't have the fire power. So he's told with Justice Williams, well, it just means that she's not protecting her goods enough. We'll transfer her to Justice Lawal. Simple. That is what happens. That cannot help. We need them to be trained and we need to admit them. I think that the bar is a bit cagey about this, and I've had lawyers say, oh, if you train paralegals and they have a bit of understanding in law, next thing we know, they will be parading themselves as lawyers. It is the duty of the Nigerian Bar Association to create a way that entrance, just like what Prof is saying, that you can tell from a mile who is a lawyer and who is not a lawyer. And you can deal with anybody who is trying to impersonate a lawyer. I will just quickly say, I had a few points in.
able to run their practices a little bit more efficiently with people who are accountable to some level of discipline as well. So there are lots of little things we can talk about, but at this stage, I would like to invite the Honorable Justice Mohammed Garba to exercise his wild card.
Thank you, Chief Udigbe, SAN. Your Lordships, Senior Counsel that are here, distinguished ladies and gentlemen, I would like to say that I'm delighted to be part of this summit, and particularly this panel. The invitation I had and received from the Honorable the Attorney General of the Federation, the Minister of Justice, Prince Fagbe Miesen, was for me to chair this panel, whatever that meant. Later on, I realized I was also going to be a panelist. And eventually, I'm a panelist, but then given a wild card. So I have a wide discretion to just talk on anything pertaining to the topic that was assigned to this panel. And substantially, most of the issues covered by the topic have been very well discussed by the other panelists. What I want to do is to briefly and also generally talk about discipline on the bench. The topic is discipline at the bar and on the bench. The case for enhanced disciplinary powers, performance, management, and court monitoring. Like I mentioned, the other aspects have been very well discussed by the other panelists. So I want to briefly talk about discipline or lack of it on the bench. And on this, it is my view that discipline or lack of it on the bench has its roots and foundation in the process of appointment to judicial office. I know the first session yesterday discussed issues of appointment to judicial office and had a very powerful panel that dealt with the issue. But my belief is that discipline really comes from the quality of the person appointed to a judicial office. Time was when appointment to judicial office in Nigeria was by invitation. People were invited to come and join the bench, particularly lawyers, legal practitioners, either in the public or private practice, were invited, and some reluctantly, I'm one of them, accepted the invitation to a judicial office. At that time, it didn't have to know anybody. All you needed was your competence, your knowledge of the law, your conduct, your character, which will be observed over time by the then judicial officers or judicial managers. Because in any place you practice, There will be people who would observe you as a lawyer, as a legal practitioner, the way you conduct yourself. If you appear before the courts, both magistrates and superior courts, you'll be watched. And people took notes. And on that basis, whenever any opportunity for appointment arises, they will recommend you even without your knowledge. Some may have the courtesy of inviting you to tell you, look, I want to recommend you for an appointment, either as a magistrate or as a judge. But oftentimes, you will just be recommended. And you just hear it over there that you have been recommended for so and so judicial appointment. Based, like I said, on your general conduct, your knowledge, your character, your reputation, which you establish in the jurisdiction you practice. Then you would expect such kind of judicial officers to be disciplined. And discipline simply means your readiness to obey rules and regulations made for a particular either appointment, office, or institution. Your willingness at all times to abide by the rules and regulations enacted for the particular office you are appointed for, without being prompted, without having been to be forced to do it. But then, over the years, things just change for the worse. Now, judicial appointments, we all know, and we must admit, are no longer what they used to be. Process. Yes, we have very beautiful rules, regulations, and even laws on qualification from the Constitution. When you are 10 years at the bar, you are qualified to be appointed to the office of a judicial officer. For magistrates, once you are called to the bar, after your NYC, you'll be qualified to be appointed as a magistrate. Most states. No, that's not even it. The way and manner that people go about seeking, lobbying, even applying to become judicial officers, to be appointed as judicial officers, you know, will leave that much to be desired as far as the discipline is concerned. Apart from applying yourself, going to lobby, you also need to know somebody, no matter how qualified, no matter how competent, no matter the reputation you have established, no matter the integrity you're known for, you would need someone who will be there for you at all stages. If you do that, and eventually you get recommended, supported, and proposed, and eventually you get appointed, of course, you disregard your oath of office as a judicial officer. You forget it from the moment you drop the Bible or the Quran. Once you enter the office, it's either favor or fear in the discharge of your duties. So where would discipline, real discipline, come in? When you have allegiance, not to the office, not to the oath you have taken, No, but something else. That's what led to so many bad things happening to the judiciary. All the accusations, the abuses. This is the genesis. If you have people of integrity, people of unquestionable character, people of learning, people of competence, appointed without having to lobby, or without having to be related to anybody or to know anybody, you wouldn't have the problems of discipline we have in the judiciary today. So in the judiciary now, you have all manners of people. People have talked about ex parte orders. They're happening every day, every now and then. Even a few days ago, there was an ex parte order by one court, another court at another place over the same issue issued a contrary order, ex parte. Only for the initial court that issued the ex parte order to now come and say ex parte again, that I have stayed the order of, or ex parte order of injunction I granted yesterday. The execution of that order is stayed. I mean, what manner of, judges do we have? And I know at various times, particularly in this hall, at our various conferences, seminars, workshops, we have discussed this particular issue of discipline on the bench, particularly as it affects judges of the Superior Court of Record established by the Constitution. But every time we come, we discuss it, we identify the problem, we know them, but at the end of the day, things will still go on as usual, as if nothing had happened. Yet, we still have very beautiful rules of professional conduct. Look, for judicial officers. We have the almighty NJC with its enormous powers to discipline judicial officers. But then nothing seems to deter the kind of people that have been brought to the judiciary to do what they want to do, they would like to do. And so we continue to go around these problems until conscious efforts, deliberate efforts are made by us to now abide by the rules of conduct, rules of professional ethics for both the bar and the bench. We merely continue to discuss this year in, year out, summit in, summit out, conference in, conference out, workshops, seminars, and we still be doing the same thing. Yes, one must admit that minor problem and minor improvements have been made, very minor, infinitesimal. But we still do the same thing the same way in spite of all the rules and regulations that we have. So I believe every necessary power for discipline, both at the bar and the bench, are in place. What remains for us is, like I said, the resolve, the sincere and deliberate resolve to abide by those rules and regulations. And this is not new, really. Because in 1990, in the programs then called Continuing Legal Education for the Judiciary, which gave birth to the NGI, His Lordship, Oputa JSC, delivered a paper which was titled Judicial Ethics, Law, Justice, and the Judiciary. That was in 1990. He said, among other things, and I quote him briefly, the do's and the don'ts are very clearly stated and set out. No judge can plead ignorance of the do's and the don'ts of judicial office. The difficulty is in the will to comply with the do's and to refrain from the don'ts. End of quote. This, in effect, summarizes what I've just said. None of us will now say, look, I don't know what is required of me. Nobody has that in his mouth as a judicial officer. But the challenge has always been and remains in the will to do the do's and refrain from the don'ts. And once again, until we are ready to really resolve to sincerely and deliberately do so, we shall continue to be running in cycle. I said I'm going to be brief and general, and I thank the moderator, Chief Idigbe, for this opportunity.
Thank you so much. Another round of applause for the panel, for the excellent contributions. I said at the beginning, at the end, I'll be sort of doing sharing some concluding thoughts. A lot has been said, and it's extremely maybe depressing. What we've been told and shared with us. But let me just add a little bit to it, because we have to bear in mind that Nigeria does not exist alone. We are existing in a world, in a global setting, and the things that are happening outside Nigeria impact or will impact us or continue to impact us. So at the beginning, I did mention IBA 2017 research, where they spoke about the factors that are driving change. But then they did a follow-up study in 2021, and they identified other issues that are shaping the global legal ecosystem, and therefore the drivers for change. And they talk about discrimination as one major issue. And so you begin to look at our profession within the global context and saying, where are we? Are we being discriminated against? Can we practice in other countries? Is our legal system fit enough for the global system? And then they speak about legal service redesign. Basically, the way legal service is being provided is constantly being redesigned globally. And very soon we may be irrelevant within that global scheme if we are not careful. They emphasize again legal technology as an issue. And, the quicker we begin to adopt many of this technology, the better. I mean, I'm happy we have United Nations here with us. And Justice Zena yesterday said, or today, right, said, all that is needed is one laptop and one desktop, and then a software. And all the courts in Nigeria would go digital. It's doable, right? These are achievable things in terms of legal technology. And then at the back of that, what is very interesting, what I've seen abroad, practicing abroad, is that the courts actually drive the technology for the legal practice, the private legal practitioners, because if the court has adopted a system, then every law firm has to key in. It's immediate, you know. I was there in my friend's office in 1985. He practices insolvency in New Jersey. And that was the day they started the filing through their platform. He couldn't go to court again to file a paper that day. I was there with him on his computer when he filed an insolvency case, 1985. Not too far away, not too far away. So and that's United States. We can leapfrog. We did it with telecommunications. But before 2000, we had only 400,000 telephone lines. Today, we have close to 200 million telephone lines in Nigeria. I mean, in how many years? So we can leapfrog in terms of technology. They spoke about internationalization and spoke about the WTO protocol, and they just spoke about internationalization. But what it means for us is Nigeria signed the WTO protocol, and we've signed the African Continental Free Trade Zone. And we were all in panic a few weeks ago when a trade mission came and signed an agreement that would have allowed UK practitioners to come here. One day we wake up and they've taken everything. Yeah, so there's a need for additional skills and training solution. They spoke about risk-based regulation as coming on. Risk-based regulation means you can say, you can practice in this area because this is what we have assessed you, this is the area you practice. You can't practice in this other area unless you have this sort of bonding or you have they do it for banking and the rest. That's why you have regional bank, you have international banks, etc. We can do it. So, however, a lot has been done. Yes, 1 minute. A lot has been done. The NBA has a bill for regulation of the legal profession, not judiciary. The body of benchers, they have a bill as well. I think what is left, we can work to harmonize it and have some work has been done in that regard, and get the political will, as Justice Mutunga told us yesterday, to try and agree on some compromise that would then pursue after this summit. But I want to just end by quoting Sir Clement T. He said something in 2004, December 2004, about the reforms in the UK when they wanted to transit from a profession-regulated profession to an independent regulated profession in the UK. And he said the following. I would just like to end with what he said. He said, reform will not be easy. Whilst there's pressure for change from consumer groups and also from many lawyers, reform will be resisted by other lawyers who are comfortable with the system as it is. Lawyers who are opposed to reforms in this review will either argue that I am mistaken or I have failed to understand the special characteristics that set the law apart, or call for further research and consultation, kicking reform into the long grass. Changes will require significant political commitment, partly to meet the expected criticism from some lawyers, and partly because reform will need primary legislation which requires scarce parliamentary time. It took them, I think it was 9 years, or 7 years, 7 years to achieve reform in the UK. So even in the UK, it wasn't easy to reform the legal profession. So all I'm saying is that we shouldn't give up. We can achieve the reform and we can make people accountable. People who know what they shouldn't do, but do it. We need to do the reform that will make them accountable, and we can change our destiny. Thank you very much.
Our moderator talked about reform that cannot be resisted. But one reform that I think cannot be resisted is to give the two panel double round of applause. Chief Awumolo called it last man standing. To me, all of you are like marathoners, 42.5 kilometers. It's been 2 days, and everybody remaining here are marathoners, long distance runners. And so what you gain is that after this, you all be part of the group photograph that remind all of us that we gathered here for 2 days. Well, Mr. Chairman, I am looking at the time and it's 5:12. When do we wrap up? 5:30? 5:30. In that case, we have 4 rules. Can we take 111 down? Nobody here. So you represent this group. And 2, we're okay, I think we can go beyond 5:30 because there are some people I can't say no to. So I'll take 3 here. Chief Awumolo, I'll start with you, Chairman, and 1 more person. Okay. And then here, I'll take 3. The lady at the middle, in front here, the lady here, 3. Dr. Miss Mandere. Okay, yes. Okay, so let's take microphone to him, please.
The chairman of this session, and I want to particularly mention the Honorable Attorney General of the Federation and Minister of Justice, Prince Lateef Fagbemi, the chairman of the organizing committee, Dr. Ajibade, my lords, distinguished, are there benchers here? Distinguished benchers, my learned friends. Oh yes, my lord, you are a life bencher. Thank you, sir. I just want to say on behalf of the body of benchers, appreciate the organizers of this 2-day national summit, and particularly having regards to the legal profession that we're all proud of. There's so much to talk about. There's so little time. Yet we have achieved a lot. And so, particularly today, I am privileged to be part of these 2 sessions. There's a lot to talk about with respect to delay in the administration of justice. There's a lot to say about discipline at the bar. There's so much going on. And I want to publicly acknowledge that the Honorable Attorney General and Minister of Justice has shown so much interest in the area of discipline at the bar. And because he is a bar man to the core, so he knows the problems of the bar. But I'm glad with the comments of my Lord Justice Garba concerning discipline on the bench. There's a lot to be done there. Yes, I know the NJC is trying its best to bring to book those who are accused of misconduct, but there's a gap in the legislation or in the constitution, particularly with respect to enforcement of discipline on the bench. I am not saying that there's a compromise, but I'm saying there's a gap in the law where the NJC recommends removal, suspension, or whatever, and the state governor refuses to acknowledge it or even implement it. And the errand office justice or judge remain on the bench, still drawing salaries and allowances. And therefore, I believe that we need to look at it very critically. And I am sure that the rapporteurs will take note of this. My Lord Justice Kanye spoke about this some time ago. So let me thank you, sir, because we have a lot to talk about. I am privileged to be part of this seminar or summit. I'm privileged to be part of this session in particular. And on behalf of the body of benchers, I want to thank the Attorney General and the organizers. And I pray that you'll be able to put into focus the issues of the legal profession. Well, some we are retiring. I'm no longer afraid of AI. I'm no longer afraid of lawyers without borders. But I know too well that the young ones, they have a lot to face. Thank you, Mr. Chairman. Thank you very much.
Well, even if we end here, that's a fatherly prayer. But I'll take you to the chairman of planning committee, please.
Thank you, my lady, and thank you for the kind dispensation. I'm told chairmen of planning committees are ordinarily not allowed to ask questions. But I think this session has been too important for me not to have three quick interventions or three quick questions. One is for my good friend Isaiah Bozimo. I know that the Administration of Civil Justice Bill, now law, has been passed in Delta State. And when we were preparing for this, we asked you specifically if you could please find out for us, are there any statistics to establish that that law in those courts, the pilot courts where it's been implemented, whether it has made any difference to the turnover of those courts? Please, I'd like you to address that. For Professor Akinshe George, and I'm glad that I'm speaking after the chairman of the body of benchers. One of the challenges I think there's a low-hanging fruit where discipline at the bar is concerned. The LPDC is a committee of the body of benchers. And the challenges you identified, the one in the Kunle Kalejaye case, etc., about the composition of the LPDC, I think we've discussed this. It's almost as though we don't want to impose discipline at the bar. Because every member of the LPDC is either an attorney general or a judge. These are people who are busy. How easy, how practicable is it that you expect them to be able to sit and deal with the thousands of petitions that are coming? Talk less of the fact that you have just one LPDC. So somebody in Ilesha, his lawyer defrauds him, he has to come to Abuja. He has to come about 4 or 5 times. Of course, he's going to abandon it and think that we're not serious about discipline. Now, I have discussed this with my lady, Honorable Justice Adefope Koje. There's a low-hanging fruit. We have a whole body of retired judicial officers who are not that busy. Why can't we constitute multiple panels of the LPDC and ask retired judicial officers to man them? Very simple solution. So it appears to me that we're not serious about discipline at the bar. My last question is for Honorable Justice Gaba. My Lord, discipline at the bench or on the bench. The NJC makes the bar representatives in that body appear like they are interlopers. Because you have certain discussions, they're allowed to participate. When it comes to discipline of judicial officers, they are asked to step out. Why? Why? We're all members of the same profession. There's no reason why the NBA members of the NJC should not participate in all of the NJC's proceedings.
Well, the microphone was taken from Honorable Justice Adefope.
Sorry.
Okay. All right, sir.
Oh, sorry.
Sir?
Go on.
Okay. I thought we could take all the questions and then we can respond. The microphone was taken from you. Do you have any intervention before we cross over to the other side?
Short one. All protocols duly established. It's about the amendment section 46 of the Evidence Act. We're talking about delay administration of justice. We're talking about having to start case novo, and that was why it has been proposed that judges that have been elevated to the appellate court can come back and conclude their cases. Now, I make a case for the fact that whenever a case is taken, evidence has been given, it must be admitted. It must be admitted in subsequent proceedings so that it doesn't have to start de novo. Because judges retire, judges die. And I know that a lot of the backlog of cases is caused having to start de novo. So if you amend, the sections up to section 46, which says that, proceedings in a, former matter can be taken in subsequent proceedings, so long as the parties are the same, they've had the opportunity to cross-examine, etc., except if the person, are far away, if the person is ill, or, amount of delay. Now, a lethargic counsel that wants a second bite at the cherry is going to say, bring the witness again. And it causes a lot of delay. So I think that that section has to be amended so that once the witness is taken, forget the fact that you need to see the witness, otherwise you will forget his evidence. How many witnesses, You remember, really. So I make a case for the amendment of that section.
Okay. That was a bonus for this group. So you just 30 seconds, please, and then we'll go here.
It was an opportunity too good to pass by without me commenting. I want to pass out an information, a very important information. Mrs. Justice Olushola Williams did talk about paralegal services. I just want to pass out the information, which is very important, to the effect that the Legal Aid Council as an institution is mandated and empowered to regulate and license paralegal services. Now, this is very important because of the role paralegals plays in access to justice. 95% of lawyers seated here, and even virtually everywhere, operate from urban areas. We hardly have lawyers in rural areas, and even if we have them, they are not as much as we want them to be. And funny enough, there are several, because of the nature of the country, there are several indigent persons, especially who are in the rural areas and who need this access, who need this information about access to justice. And like I said, the paralegal operate, at a certain level. Though they are not lawyers, the fear that they can always impersonate lawyers is always there, but it can be checked and taken care of. Now, the important thing is that we have started a program whereby we develop curriculum with some universities across the country, about 6 of them, 3 in the north and 3 in the south, with active support from ROLAC and of course Dr. Uju Agomo. We want to have the process completed, and we advertise the need for people to engage paralegal services in their activities as an access to justice. Thank you.
Chairman, do we have space for people to pay for commercial? Okay, I'm here now. In this place, do we have the CJ Kano here in this group? Okay. Okay. Where? Okay, please. Start from, please, yes.
My Lord, presiding, distinguished participants, so grateful at least I made it back here. When I came in, everything was almost gone, but I still felt the vibe from the last discussion I listened to. We were in court all day, that's why I came late. My question is this. We are all into this profession. There is no lawyer who doesn't know his boundaries. But when there is a failure, it means we ourselves are failing. It's more or less an individual thing. All of us must look inwards and also be able to mentor those who are coming from behind. At no time are we having more challenges about discipline than now, when you have all sorts of technology coming in. You sit in court and you see on social media, your cases are being discussed freely. They are calling judges names, insulting everybody. And this had never been part of our protocol. And so we begin to wonder, is it that we've lost it all out? So what can we really do to push the boundary forward? Because if we get stuck where we are, definitely this profession is collapsing. And we must wake up all of us must be involved. Number 2, I did come to discover also that we have systemic problems. I sat down the other day and I looked around and I saw that almost 90-something% of NJC disciplinary things they didn't pass through the court. They all voided and returned back. Why was it so? Breaches of procedure, failure to comply with regulations, and all manner of things. So we must look at the system and also look at the kind of rules we set for ourselves to maintain discipline. So that because charity must begin from home. If we are talking about the larger society, we must look at what governs us and how we handle them. Once we are not ready to do that, then we are not ready to succeed. So I think we need to go back and look at it there. I have been party to sitting on some of those cases that we voided. I discovered that there are some simple regulations. NJC, you created regulations and you are not complying with them. And then you want us to close our eyes on the bench and say, oh no, let it go. It's NJC. No, it doesn't work like that. Charity must begin from home. If you are talking of justice, justice must start from the house of home of justice. So we must be able to own up, be responsible enough to do what is needful, not circumventing anything in the name of trying to do discipline, and then they run to the court and they get escape route and they go away. And that is part of the major problem and the challenges that are now rearing its ugly head. Lastly, sirs, you'll come to discover that the junior ones that are coming, they are too much in a hurry. I can bet you. They are too much in a hurry. That's why they go into all manner of things, doing all manner of unorthodox things. And we must try again to recodify some of our things. If, for example, we go by the orthodox way of checking traffic rules, you see a lot of people, a lot of problems will continue to linger, but there are some rules that are strictly to be complied with. Strict liability offenses are there. We must be ready to create some. Once anybody is caught with this, you are there liable and you are dealt with. If you don't do that, because every sickness has its own cure and mode of cure, the one that has come requires a very radical procedure, and we need to take that. Thank you.
Okay, we'll streamline it this way. It's okay. You're already standing.
Thank you very much.
You, the lady behind, and then the CJ Kano, we are done with this group.
Well, by fourth intervention, I don't know, any member of the panel can respond to it. But most likely, I think Justice Sena, most likely is the best human being to the answer. Yes. You see, when Mr. Fagbolu mentioned the issue of the judges and the courts, on the basis of laxity in the way and manner they conduct proceedings in their court, I realized that truly there is another threat that they get from the NJC directly. In most cases, what I find out is that more than 60% of them are really not in charge of their court. They are not in charge at all. In fact, lawyers just toss them around here and there. And when you complain, they say, can't you refer the matter to LPDC, for example? The first thing they will say, look, if I go and refer it to LPDC, they come and ask me to start giving evidence. Come over to come and give evidence, adopt your statement. That's number one. The second major one is that should the lawyer write, no matter how frivolous it is, a petition to agency, you have to go and defend. Use your money, go through torture, trauma, and at the end of the day, the petition is dismissed with nothing for you. So why do I want to put myself in that kind of situation? So I believe that this is an area that needs to be addressed along. Now, to Fernandez and probably my brother, Bosimo, under the ACJL, which is the forward, I don't know whether it's in the ACJA, Jeremy probably will do. I know that you cannot demand for judge's note as of right, as a party to a proceeding under the Lagos State ACJL. Now, I tell you a situation. I agree entirely that verbatim recording, in fact, we get transcript as of right in Lagos. But the challenge is that most of our final written addresses are usually based on the transcript from the verbatim recording, right? Now, you find a situation, which of course, in a criminal matter, for example, recently, where I just said to me in the open court, I said something, she said, no, it never transpired. I told my lord, it did. He said, how? I said, I have the transcript. I read it out. He said, that your transcript is not reliable. This verbatim recording is not reliable. I said, my lord, if that is not reliable, what would be reliable? He said, it's my own note I rely on. I said, my lord, can I have your own note? He said, no, you can't have my own note. I said, my lord, then what do I do? And she said, okay, the best I can do for you, I will ask them to give you the audio recording. I said, okay, fair enough. I will use that to corroborate whatever I have on the transcript. The next adjourned date, when I said, they are not giving us the transcript. He said, I changed my mind. So you go and you should have recorded it yourself. I said, my lord, if I record it and your note is at variance with what I've recorded, what happens? You are going to base your judgment on your own note, and I have no entitlement to it. So what I'm proposing or suggesting, if possible, is that your entitlement, the draft, we incorporate judge's note. If that is what we cure it, that's number one. Now, this last question is on this proposition on virtual hearing. I don't know whether it's best to put it in the, I don't even know which of the enactment we are going to put it now, maybe the Constitution, but I have this idea that we don't have to keep on compounding the Constitution, everything Constitution. Maybe we have a separate statute for that purpose. By now, to a large extent, I believe that in all applications, we can take them virtually. You don't have to keep on going to court for application. Only trial should take place in open court. And I don't know how you are going to address that, but I think it's my own proposition. Thank you very much.
Thank you very much for the opportunity. My name is Tony Basharun. I'm a senior advocate of Nigeria. Before I say anything, I think I want to especially thank this panel. I deliberately waited till this time because I felt, having practiced for about 36 years, this issue of court administration, discipline, bar and bench, and quality of staff, especially administrative staff, are becoming a major problem. First of all, I must say that we have become endangered in the profession. And if care is not taken, especially we litigators, as Mrs. Adekoya refers to us, we may find ourselves out of job. Now, the issue I notice is, first of all, attitude of the registrars. I think it is time to begin to concentrate on them, their qualification, the kind of people. Should they have a little bit of legal knowledge? Because you go into a court, a federal high court, and you find them sharing bags of rice or sleeping on the bench, in the inner bench. That's one. Then the LPDC. I was a prosecutor for like 4 years there. And initially, NBA used to sift petitions that come to the LPDC, so that by the time the petition comes, it becomes the Nigerian Bar Association versus the erring practitioner. So it takes away from the individual, except maybe you want to testify. Even then, they recognize that we could take written depositions, which did not necessitate having to travel to come and give oral evidence. But after it was amended, it now became a 3-window. An individual can come there directly, the NBA can file, and even the LPDC itself can institute an action. But then, according to Professor George, we don't even know the number of us. Even those that are disbarred, they don't get to be registered, and they still, if they're in pardon me, sir, there's nothing wrong with Port Harcourt. I love Port Harcourt. If they're in Port Harcourt or Begema or Degema or those places, they go back and continue practicing. So you see, I think we should really, really spend time streamlining ourselves. The accountants never allowed their profession to go berserk. So I'm quite passionate and I'm grateful it came up. So I think I want us to address these 3 issues I've pointed out, because I believe if we can handle that, we would have gone a long way to help the profession. Thank you very much.
Thank you very much. And so finally for this group, CJ Kano, do you have anything to say? And then we'll wrap up for this group.
Actually, what I wanted to say and raise has been addressed by the chairman planning committee on discipline, the bar, and the fact that it's not. Yeah, the fact that it more needs to be done. We need to have more of these committees at all levels. The learned Justice of the Supreme Court, when he was giving his intervention, talked about a case that happened of recent. I'm not sure whether it's the one that took place in Kano he's referring to, but one happened in Kano just a few days ago when a party obtained an expedited order at the High Court. And the following day, a lawyer filed an application at the Federal High Court where a contrary order was also obtained. So the thing is, it was carried out in the papers anyway. And the thing is, if Perhaps the judge, the Federal High Court judge, may not be aware of the initial ex parte order given the day before by the High Court. Otherwise, I don't see how any judge would now give a counter order given by a judge, of a court of a coordinate jurisdiction. But then the lawyer in that case shouldn't he be held responsible? Since the bar, some of the members of the bar will have read these in the papers, they would have been aware of what had happened. They don't even need for anybody to write to them to look into this issue. This lawyer should be called to order. Ask him, on what basis did you now go to file a case at the Federal High Court a day after an order has been obtained at the High Court on the same issue and served on your clients? I mean, this is the kind of things the lawyers do that really brings the profession into ridicule. So I think we need to have more of these LPDC committees, and also the lawyers should probably need to do much more to put a rein on some of these actions taken by legal practitioners.
Thank you, my lord. So,
thank you. I guess I was the first person to raise my hands, but unfortunately, because I'm not Dr. Banere. But my name is Yeka Kotoyes here. And I have two questions that initially penned down. Prof, Mr. Tudefa Bondes here, and then my brother Fernandez. And then in the course of my teacher's presentation on ethics and discipline at the bar, as the Professor Akishaye George, the third question came to my mind. Now, the first one has to do with virtual hearing. Dr. Banere went over it a little bit, but this is my question. Is it not possible to raise the policy paper from the Federal Ministry of Justice so as to synchronize these points? And I'll give you my mindset. During the COVID period, Ogun State Judiciary was the first to come out with the practice direction that they were going to be taking virtual hearing. Unfortunately, for some reasons, I'm not sure they were able to achieve it. Then Lagos State came, and because of issues of facilities and then infrastructure, we had challenges until recently. I'm coming to Borno because I learned of that last year during the bar conference. So, and Lagos State now came with this, that you have to pay 30,000 naira now to do Zoom hearing and stuff. But I think we need to have a uniform position. Borno's situation is commendable. I was at the session where the representative of the CJ, in fact, I thought my lord who took that session was the CJ. I had to take his number. And I was impressed with what he demonstrated because it showed to us that the case was filed that day and he did their assignment was done immediately there. Dr. Ejibadi could recollect. And for me, that was fantastic because in these days, if we don't move beyond where we are, like everybody had said, in another 10, 15 years, in fact, I used to say this, with the advent of AI and other forms of technology, in another 10 or 15 years, any lawyer or any law office that is not techie savvy will be out of job. And that is the stark reality. So we need, my question is, what, or can't we have like a policy paper from the Federal Ministry of Justice, the Attorney General's office, to say, let us do this and let us do this. That is one leg. Prof, in your presentation, you referred to, I think, section 3, sub 2, I'm not sure, of the proposed bill. And you said that it incorporates a process of inquiry into why a judge will not sit, and then a feedback mechanism. Let me give you my experience yesterday. I had a matter that was supposed to come up for argument. Typically, I'd asked my colleague in the office to make inquiries from the registrar, the judge will sit. They said the judge will sit. I got to the Federal High Court and by 9:30, they just came and said, oh, we are sorry, Judge is not going to sit. And that was the third time that matter will be adjourned. A matter that was filed in 2018 or 2017. The client went back. Of course, the client came from abroad, he went back distrust. I just had to plead with him. How do we ensure that in such a situation, I have a right, not only as a litigant, but as even the user of the service? Because whether we like it or not, we are providing a service. As a service user, that I should be able to ask the judge, especially since we had made inquiries prior on the court platform in writing prior to that day, that I demand and deserve an explanation, not only an apology, of why you did not sit. So that is my question. To Professor Akishaya, George, this intervention may not sound particularly nice, but it is what I had seen in the little years since I started practicing. And I can say proudly that I'm your product. I think the discipline should not be only to lawyers. It should even be to my lords on the bench. I've had several instances where judges will come and sit with brown shoes. Wearing brown shoes. In fact, there was a particular instance, yes, brown shoes. We walk into the court now. There was a particular instance in a state in the South. In the state in the South. I had to tell the judge that it's either he goes back to change or I leave the court. Yes, I can mention the name. Unfortunately, we had a situation where there was a senior counsel in court and the senior SCN saw it too and asked that we go into chambers. It's so appalling on both sides. It's not peculiar to lawyers. I've had instances where justices of the Court of Appeal will tell a lawyer, shut up, what are you saying? I'm sorry to say, that's why I said my first experience with my Lord Justice Isa Salami in Kaduna was not good at all. So when were you called? And I think it's a little bit demeaning. If you are not careful as a young litigation lawyer before such a judge, you may get discouraged and feel that you are being bullied. So discipline on both sides, it's very key and important. And I think it's one point that senior members like you who are involved in legal education need to assist us in how to get around it. Thank you so much.
And I'm very grateful we didn't miss you. Thank you for your contribution. So let's go to the other line. Madam, I'll come back to you to round up. Thank you. CJ Bruno, you
I use my long hand to the advantage, to my advantage.
Go
my
ahead.
Lord, my question is to my Lord, Honorable Justice of the Supreme Court, Lord Honorable Justice Gaba, on virtual court hearing. Myself, Moyoni Banjo, and I believe a couple of others litigated the first virtual court hearings before the Supreme Court. And I'm not pleased to say that we were thrown out then. I'm wondering now, with time, whether my Lord can just share an insight with us, whether with time, if the matter of the constitutionality, and the reason why we went to court, why we went to Supreme Court then, was because we were having conflicting attitudes with our CJs. In my own state, the CJ said, totally unconstitutional. A couple of other attorneys general then were having the same issue. So we decided, okay, we'll go to the Supreme Court and finally get certainty on the matter. Regrettably, we didn't get that certainty. I think we were tongue-lashed across the bench. But that was then. I'm wondering now, with the evolving of how we now look at things, I doubt whether there's anyone will argue now. Oh, I'm sorry, my Lord. And can your Lordship hear me now? So the questions are, if we come before your Lordship again on the issue of virtual court hearing, with your Lordship's opinion, would your Lordship think that attitudes has evolved now, that it has changed, and your Lordship may now give a favorable approach, sir? I thank you.
Let's give it to Honorable Justice Anna, please.
Thank you very much. I don't know where to start because a lot has been thrown at me. But first, let me start where I think I'm much more interested in. Clear the air about the automation of the system we use in Borno. Just to make it clear again and reiterate that it's not a Borno-specific software. It's a National Judicial Council issued software for all the high courts, Supreme Court, and Court of Appeal. Any high court, I repeat, any high court anywhere in Nigeria that wants e-filing into that court and to manage its cases through that electronic case management system can use it having just one desktop and one laptop and internet connection, period. That is all a state chief judge needs to provide for the courts to start using it. Delta is using it, Bayelsa is using it. The only addition is for the central registries, yes, depending on the size of the court, the registry, 1 or 2, it's all based on the roles. It's the roles that they have that need all the systems. And some mobile roles, we call them, we recommend laptops and even iPad. And for me, it's been long, I've not even used my laptop. It's this one I use. And it's available to all the courts. I have even knelt down figuratively to beg, especially the federal courts, because that's where we make the impact. All this I'm talking about would have been history if any of the federal courts that have a lot of visibility have deployed this code. Thank God I've convinced the CJ Federal High Court now to just give us 10 laptops and 4 to give his court in Lagos 10 desktops and 4 laptops, and we'll roll it out. And I think thereafter people will understand what we're talking about. And filing, because of the unique system we designed, Chief Idigbe, we have gone through a lot during the COVID with him. The system, you don't need to register in anywhere if you are a Nigerian lawyer and registered with a legal mail, you just file in straight to any court because you're recognized through that mail. That's how it is. And from Canada too, you can file so long as you have that because you go through a process before you get that mail. So that's your legal identity, that's your authorization, and that's your pass to file. And you file, and then it goes through the motions, and up till the time it exits the system. But particularly what I need to emphasize is this, that we are still held back. This, we call it dumb. We are still dumb. I mean, those who know technology know what. For example, just give me, let me give you why I can be. I think yesterday or today I used frustrated. Microsoft, because our system is even on the Azure platform, and saw what we're doing and put their dollars down. And right now we're developing an AI, artificial intelligence judgment right drafter. Yes, it can draft judgment for you. AI can do lots of wonders. But you know how the thing works. You have to train the algorithm with data. So far on the system, we have only, I call it only 1.3 terabytes of data. As at yesterday. Only Borno, of course, having started since 2020, has the largest data, some from Delta and Bayelsa. Now imagine if we had like 20 courts, these big courts, because, okay, I'm saying this because the bigger your data, the better the algorithm. We have to now resort to scanning from the Supreme Court and capturing right from the High Court cases. I mean, it's all frustrating. So the point is, it's available to all. And I'm particularly pleased with Hadiza Usman's comment that we all owe it, including civil society and everything. Please harass your chief judges. If the chief judge has any handicap and you are a senior lawyer in that state, go to the governor and say, look, Mr. Governor, you are holding our state back. There is something already that the National Judicial Council has spent a lot of money on. And see, even remote state like Borno, they are already automated. I can sit down here in our advanced state and file in cases into the High Court of Borno, but I have to now go physically to file in your state. Is that good for you? I mean, do something. Help us to get this adoption, because that's our headache now. Without the adoption, there is a limit to how far, how much we can roll out. I must commend my friend, my short friend here, because please forgive me. It's important that I give these stories because I've been here throughout, and some of these stories illustrate certain things. I was on an assignment in Cairo when he called one day and said, please, can you come to Ekiti? I said, what is it? He told me, I said, we can talk now. I can't. He said, oh, please come. Come. My governor insists that he must see you. You know why? I'm coming to that because it's yesterday somebody mentioned who is the governor or who is integrity that we're talking about. His governor, I didn't even know that of what was going on. His governor was going through the ease of business, doing business index or something like that. That was the first time I was hearing. And then saw that sectors were being scored, marks. And then he came to Ekiti, his own state, and saw that they were scoring very low. And lo and behold, he went to Borno, and saw Borno scoring very high marks. He said, come on, Borno with all their Boko Haram and Sahara Desert performing better than us. And then, well, I told him, I know why. And he said, please bring him down. So you can see where leadership counts. And I said, okay, I cannot. He said, no way. He said, you must come. Of course, I went because of him. So now, before I start answering just two, I'll limit it to two. Yes, two specific questions that have been asked of me. First, there is a group, I'm sure, that will go and sit down and look at these things and propose what amendments and whatnot. Mentally, I call it the group that will answer the question, how do you legislate, regulate, or institute processes to mitigate against pervasive integrity deficit and shamelessness in public service? If you like, I can write it down. If we can't answer that question, our assignment will not be done, because a lot is caused by integrity deficit. Now, to answer first the issue raised by the planning committee chairman, the question of non-lawyers not participating in disciplining judges is a constitutional matter. The constitutional provision that set up the schedule that set up the NJC and provided for the participation of lawyers. I'll just read the proviso after blah, 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 blah. They provided that the members shall sit in council only for the purpose of considering the names of persons appointed to the superior courts of record. So I think it's cut out for this kind of situation. So you know this is what it is, and if there is going to be proposal for change, then that has to be done. But nobody can sit down and say, okay, come in and do this thing, because it's clear only for that purpose. Now, another issue, one raised by Muiz, is about why not have petitioners deposit money when their petitions are to be considered, so that lawyers and judges and those persons who come in to defend, who use their own money, and then the petition is thrown out and they go away. Look, I'm culpable. I've always resisted that. It has come up in council and I've opposed it. I think we all, I see the point being made, but I also see a situation whereby council will be seen to be restricting and making it impossible for certain persons to petition. Even with this one, how many get disciplined? So if you now introduce heavy deposit, I mean, it's like making it impossible for certain persons to file petitions. So sometimes there is something, I mean, there is a cost to some of these things. Not that it's a good, this thing, I see your point, but how do you do that without also now closing the gate, as it were, to persons who are not rich enough to make that deposit? So, well,
okay,
it's a matter of...
Thank you, my lord. Thank you. Thank you.
Am I now discharged?
Yeah, yes.
Just
yes.
last
Yes,
one.
thank you very much, sir. Thank you very much. Well, our time is fast spent. If you have comments, questions, you can write them down to the committee, but give it to the, she has promised me to do only 30 seconds.
No. I didn't promise that. Just for me to stand on existing protocols. My name is Mandy Asagba, Vice President of Nigerian Bar Station. Third Vice President, please. My question is this: what exactly is our reality? Is the system built to truly render justice or injustice? Before I start, I must commend all the panelists. You guys have done a wonderful job. I really appreciate you. And I believe we're on the right track. So now, looking at the system, I'm particularly worried about what I met in the profession when I came in. My very first experience was horrible. Very first experience as a lawyer. I don't want to go into that story. It's going to take our time. But I ask myself, and I ask anybody who cares to know, what exactly are we after? You come to court, number one, you go to the courtroom, you see the cost list, and you see about 50 cases on the cost list. Are we there for justice or injustice? That is one. Two, as a lawyer, you get to court, you are only going in for 1 or 2 cases. You're going to be in court from morning till God knows when, maybe 4 p.m. And we're there for justice, isn't it? Are we really aiming at justice or injustice? I keep asking that question. Now you want record of proceedings. You apply, and for many months you are still waiting for record of proceedings. You go to the court, you go see the registrar, you do all you need to do, but it still takes forever for you to get the record of proceedings. Are we for justice or injustice? I keep asking, there's so many questions agitating my mind, and I keep wondering.
It will be injustice
What's
if I allow
the way
you to.
forward? Now, what is our reality? I ask the question, is it for justice? The problem we are having in Nigeria today is problem of justice.
Okay.
Hold on, I'm not done, please.
No, please.
Let me say so.
Please.
We have conflicts here and there. We have crises here and there. Why do we have this conflict? Because of injustice done to one person or the other. To communities, injustice. So you and I, injustice. I've suffered injustice. So many people have suffered it. And what is the way forward? My question is, when we are doing this reform, what exactly are we looking at? We're talking about economic downturn. Everything is upside down. The system is corrupt. Everything still boils down to justice. So now, for us to get it right, we need to look inwards. When we are appointing judges, we must be sure that we are appointing people who are brave, courageous, fearless, who are ready to do justice. That is very key. Then we're also looking at at the point of getting to the law school or even universities, who are those students who are taking to read law? Are they people who are ready to really do justice?
Thank you.
Thank you.
Thank you. Thank you very much. Thank you. And now I'll take it back to the panel. Prof. And your panel will take the questions that concern you, and then moving on to the next panel, please. Prof.
Okay, so thank you. I have 2 questions that are about the same. No, there are 2 questions about the same, so I'll just answer. For virtual hearings, Mr. Baniweyase had indicated that why do we need a constitutional amendment? The problem is in the statement I made when we started it. You finish a matter, you run through, and then somebody makes a brilliant argument at the Supreme Court that is not constitutional, and that brings the entire matter to an end. So if ordinarily, ideally, I would have said we shouldn't be a constitutional amendment. I don't like it, but the situation we find ourselves in, if you don't make it that, then you're going to have somebody come and set it aside, likely. Thank you. As for the policy, I agree. I think we should, something like that should come up. I will look into it. Thank you very much.
Doc, thank you for that question. On the statistics for the civil justice law, that law is currently under a legal challenge. Happily, we argued the case on Monday with the judgment to come out on the 9th of July. So we don't have statistics for that yet. What we do have statistics for is for the criminal justice law, which sought to do the same thing. And I can just give you some of the key metrics. So there's preliminary data that looked at data sets involving 11 cases. and that was monitored between March 17, 2023 and July 10, 2023. So I'll just give you the averages. On average, it took 5 days after a charge was filed to be assigned to a court. It took, on average, 34 days after the filing for hearing to start. In that period, 45.5% of cases were completed. Of the concluded cases, it was an average duration of 155 days. So that's about 5 months. The shortest duration was 71 days, and the longest duration was 234 days, about 7 months. So that's encouraging preliminary data. I think what needs to happen is there needs to be consistent data coming out so we see if it's sustained. And I think there needs to be qualitative data as well to support the numbers. So we know the context in which those 45.5% of cases were able to be concluded, whereas others were not. And I also wanted to see a difference in differences comparison between the pilot courts and the regular courts, as it were, to see if there's an appreciable difference between the conclusion of cases. But I was quite encouraged to see that most cases were concluded in less than 7 months.
Dr. Barry, I think maybe just to further reinforce the point made by Fernandez regarding the issue of virtual hearing and why we think that maybe a constitutional amendment is important is because of the express words used in the Constitution, hearing in public. What would constitute hearing in public? Their views are divided as to whether when you go on Zoom, for instance, people will say that is public. Others will say it's not, as the case may be. And if the Constitution uses the word hearing in public, so we thought maybe the constitutional provision were just anything? Yes.
I mean,
Okay.
the point I'd want to just respond to very briefly is Mr. Kotoye's point about hot not sitting syndrome. And, you know, when I started practicing in 1988, this was not a problem. It wasn't. I served in Kaduna State as a youth corper. There was not a single day, and I was in court almost every day for the whole 1 year. And there was not a single day I went to court and the court did not sit. So the question we have to ask ourselves is, how did we get here? It's a degeneration in our values. And it's not as simple as that. So it will be belittle judges to say open a register for judges to sign attendance every day. It will be very belittling. The NJC needs to send the right signals. Court hearings are sacrosanct. If we did it before, then we can do it again. And we need to just ask ourselves how we got to this point. It's as simple as that. Thanks.
Just 2 words or 2 sentences. First, I had made my first comment was about this notion of a system. So if till we see this as a system, it becomes problematic, even in terms of case management system. When we piloted in Enugu and the FCT, what we found out that it's not just about one agency. There must be a willingness to share even data. So again, understanding that this is systemic. My last comment, yesterday, 100 and maybe 19 people were out of a custodial center. We do so much upstream and we don't see that connection downstream. No matter how much you do, just 1 hour, less than 1 hour, all of the work you have done may just be like nothing. So again, let's make sure that we are seeing this as a systemic thing and that the judiciary must not just only keep being there. Sometimes move into custodial centers and see what is happening. Sometimes move into detention facilities and see what is happening. Not just under Section 34 of the Administration of Criminal Justice Act that enables magistrates to visit some places and police stations and all that. But there are a lot of detention facilities that nobody is visiting. Close to 19 in this country. Nobody knows, not one person knows the total persons that are there. Yes, nobody actually. So the question is that we need to understand the system. Thank you. Sorry, it went to.
Yes, there were two questions for me, and I'm sure Dr. Ajibade has gotten his answer from the Honorable CJ Borno, why lawyers had to exclude themselves when issues of discipline is being discussed at the NJC. Now, to the question on virtual hearing, my opinion, I'll wait until the issue comes before me on the
Prof. MBA from Kaduna. I would like to suggest, in addition to what Dr. Ajibade mentioned, suggested, that retired justices could be engaged to sit at LPDC to try cases of professional misconduct. That the same retired justices could also be used to try election petition cases, as that will help to eliminate the delays of cases before judges who would sit for election petition tribunals every election cycle and off cycle. This could be done with necessary amendments to the relevant electoral laws. Thank you. I think that's the only thing.
Thank you very much. Very quickly, we'll present the plaques to the panel. These two panels will be our father head chairman of the Board of Benches, Chief Awumolo, will be stepping off here to present to this panel. And then the other panel earlier in the day, we have the Honorable Justice, my Lord, Honorable Justice Ejiada presenting to them. But Chief Awumolo will be stepping forward now.
Professor Peter Akpa, SN first. No, it's individual, sir. It's individual or what's... Okay, the picture. Okay, at the background, yes, please. But Professor Peter Akpa, son, you first, sir. Then followed by Mr. Isaiah Bozimo, Senior Advocate of Nigeria. Yes. Individually, please. Yes, please. Professor Peter Akpan, the SN. Oh, God. Professor Peter Akpan, SN, please. No, they brought the wrong. Sir, please. Then followed by Mr. Isaiah Bozimo. What's that?
Thank you. I present to you Professor Peter Akpe, SAN, as a moderator, Courtesy National Summit on Justice 2024. Date 24th to 25th April 2024. Now I know what to read there.
You can just hand them over.
Okay. It's better, be? Okay. Because of time, to my brother Isaiah Bozimo, on behalf of the organizers, thank you for your time. Thank you so much. Thank you. Tunde,
So I'm collecting this gift from my grandmother.
Mm.
Yes, sir.
Okay, interfering.
Okay, yes.
Thank you, sir. Just stay around, please. Mr. Fernandez Marcos Obiene, Junior Advocate of Nigeria, I said.
We didn't call him that.
Incoming Senior Advocate of Nigeria.
Please, no back. Please, sorry, just close one. Okay.
Let's wait on. The panel is taking a picture with the chairman body of benchers, Chief Adegboyega Awomolo, Advocate of Nigeria. Thank you. Thank you so much. Sir, you know you're all done, sir. Chief, the second panel, my Lord, Honorable Justice Muhammad Al Garba, JSC. No. The Chief Anthony Idigbe, Senior Advocate of Nigeria, the moderator of this session. Chief Anthony Idigbe, Senior Advocate of Nigeria, will be presented with his award. After Chief Tony is Justice Olushola Williams, retired. My Lord. Thank you, my Lord. Thank you so much, sir. Followed by Miss Adiza Osman. Miss Adiza Osman. Miss Adiza Osman's award, please. Please, Professor Yemi Akinshaye George, Senior Advocate of Nigeria. The panelists should please wait behind to have a group picture with the chairman of the body of benchers immediately. Please, my Lord, the JSC, Miss Adiza Osman, Justice Olushola Williams, my Lord, Justice Olushola Williams, and Professor Yemi Akishaye Judge, place a group picture with the chairman body of benchers. Thank you, my Lord. Thank you, my Lord. Thank you so much. Please, the panelists for the morning session should please come up stage, and I invite my Lord, Honorable Justice Adai, JSC, to come around to please present the awards for the panelists of the morning session of the summit. Okay, sir. Thank you so much, the chairman body of benchers, Chief Awomolo, Senior Advocate of Nigeria. My Lord, thank you. Let me hold your back for you, sir, so that you can do the job, sir.
Okay.
Please, for the earlier session, we have Dr. Okay, please, a picture.
No.
Okay, so you go first, sir.
No, they called me last.
Okay.
They called the,
My Lord, Honorable Justice Issa Ayosalami, President Court of Appeal, retired. My Lord is on his way for your award, my Lord. Please. For his plaque.
Justice Salami.
Justice Issa Ayosalami, PCA. Thank you so much, my Lord. Thank you so much, my Lord. Thank you, my Lord. Thank you, my Lord. A round of applause for my Lord. We are privileged to have you around, my Lord. Thank you so, so much. After my Lord, the PCA retired is Honorable Justice Oludotun Adefokwe Okoje. Adefokwe J. Okoje. JCA retired. My Lord, I'm sorry. He landed. Má sọ fún wọn. Má sọ fún wọn. Má bínú. Please, thank you so much, my Lord. Thank you so much, my Lord. My Lord, I'm so sorry for the for the missed call. Following my Lord is Mr. Robert Emukwero, Senior Advocate of Nigeria. I know this one very well. No, it's Emukwero. Thank you so much, Leno Silk. Thank you, my Lord. Please. Thank you so much. Then followed the next session as my Lord, the CJ of Borno State, Honorable Justice Kashim Zena. Thank you so much, my Lord. Thank you so much, my Lord. Then we have Professor Bolaji Owasonye, Senior Advocate of Nigeria, sir. Thank you so, so much. Thank you so much. Then the last but not the least is Dr. Babatunde Ajibade, Senior Advocate of Nigeria, for his award, please.
Here that when Dr. Ajibade is getting to, I'm getting
Okay. Then we have the alternate chairman of the Summit Planning Committee, Dr. Balkis Saidu. Please, for your plaque, please. Doctor. There's a round of applause to Doctor. And okay, Professor Tabi. Okay, is he around? Please, Professor Gobadia, for his plaque, please. Professor Gobadia for his plaque. Professor Amazing Gobadia. Please, where is she? Prof? Please, my Lord is waiting. Is he around? Please, Professor Tab, you should please come over to the stage. Okay. Thank you so much, Prof. Thank you so, so much, Prof. Okay, Professor Tabu. Please, just give it to me. Please. For your what, please? For your black, please. No group picture. Okay, please. Next is for Dr. Balaki Saidu to give vote of thanks on behalf. Thank you so much, my lord. Thank you, my lord. On behalf of the Summit Planning Committee. Doctor, please. Please excuse us, please. So sorry to bother you. Thank you, Doctor.
Thank you so much. My noble lords, learned seniors, colleagues, ladies and gentlemen. It has been an incredible 2 days of knowledge sharing, thought-provoking truth-telling, and fascinating perspectives. My name is Balkisu Saidu, and I'm the alternate chairman of the NBA Judiciary Committee and a member of the Summit Planning Committee. It is my privilege on behalf of the organizers to acknowledge the contributions of those who have worked incredibly hard to make this event possible. First of all, I would like to express our deep sense of gratitude to His Excellency, the President of the Federal Republic of Nigeria, Asiwaju Bola Ahmed Tinubu, GCFR, represented by His Excellency, the Vice President, Kashim Shettima Mustafa, GCON, who spared most valuable time to not only declare the summit open, but to stay through the keynote address. It is on record that this administration has, right from inception, been exceptionally supportive of the various initiatives promoted by the Federal Ministry of Justice aimed at reforming the justice sector, which is not surprising considering the transformative blueprint executed in Lagos State during the time of Mr. President as the governor of the state. We thank Mr. President most sincerely, and we look forward to even more extraordinary reforms in the sector under this administration. We thank the leadership of the National Assembly, especially His Excellency, the Senate President, and Chairman of the Judiciary Committees of the Senate and House of Representatives for their positive disposition in this venture. As we cherish the support thus far, we wish to use this opportunity to give notice that we will surely be leveraging on the cordiality time and time again for more support, especially in the area of passage of the reform bills proposed at this summit. We look forward to building a stronger partnership in that regard. We thank my Lord, the Chief Justice of Nigeria, the Honorable Olu Kayode Ariola, GCON, for his consistent support to the cause of justice reform. In the run-up to this summit, our committee presented my Lord with a list of requests. I can confidently report to this summit that none of those requests was refused. We are indeed grateful. Our guest speaker, my Lord, the Honorable Dr. Willie Mutunga, EGH, former Chief Justice of Kenya. We wish to express our sincere appreciation for the wealth of experience and valuable insights he shared with us. That will, without doubt, be impactful in inspiring further reforms in the Nigerian justice sector. The chief host, the amiable, humble, and ever receptive Attorney General of the Federation, Prince Lateef Fagbemi, SAN. I don't think there are words that could express our depth of gratitude for the leadership he has shown in spearheading this partnership and for always being accessible to the members of the planning committee. I actually sometimes wonder whether the Honorable Attorney General's days have longer hours than 24. He is indeed a source of inspiration and pride, and exemplify the kind of accomplishments that are possible when round pegs are placed in round holes. The NBA president, the gentle giant, we thank him most immensely for re-energizing the bar and pragmatism in leadership. He exemplified the eagle that he talks about regularly that keeps soaring higher. And my noble lords, the honorable justices of the Supreme Court and Court of Appeal, chief judges, grand caddies, presidents, and judges of other superior courts and other judicial officers serving and retired, we are deeply appreciative of your presence and insights. We also thank the chairman of the Nigeria Governors Forum, the governor of Kwara State, His Excellency Abdurrahman Abdulrazak, the Honorable Minister of Interior, the Chief of Defense Staff, General Christopher Goabe Musa, OFR, and the former Attorneys General of the Federation and our esteemed seniors. The Solicitor General of the Federation and Permanent Secretary, Federal Ministry of Justice, with whom we have worked closely in the design of the program and budgeting of this event. We thank her for her indulgence and patience. The appreciation of the committee members also goes to the present and past national officers of the Nigerian Bar Association, the chairman of body of benches, sir, heads of sections of the Nigerian Bar Association, our host, the administrator of the National Judicial Institute, Honorable Justice Salisu Garba, retired, and the secretary of the National Judicial Council, Mr. Ahmad Gambo Saleh. We equally express our gratitude to the Honorable Attorneys General and Solicitors General of States, heads of justice sector institutions, heads of law enforcement and other sister agencies, directors and other staff of the Federal Ministry of Justice, our resource persons, moderators and speakers who have traveled from far and near. Thank you so much for the invaluable contributions. Our development partners, the European Union, UNICEF, International IDEA, and UNODC, we appreciate their continuous support in many of our reform programs, and we look forward to even greater collaborations. Our masters of ceremony, the rapporteurs, media and IT personnel, the event planner, security personnel, our ushers, we are grateful for the professional manner in which you conducted your respective services. I now come to the industrious members of the planning committee. I think they all deserve personal mention. If you are in the hall, please stand for recognition. Starting with our, I think I should call out your names because you really worked incredibly hard. Starting with our most respected Honorable Justice Mohammed Lawal Garba, JSC, who represented the Supreme Court on the committee. Our tireless and assiduous chairman, Dr. Babatunde Ajibade, SAN. Mr. Osaro Ehobame, SAN. Professor Peter Akpe, SAN. Professor Dakas, CJ Dakas, SAN. Professor Yemi Akinshe George, SAN. Mr. Rafiul Lawa Rabana, SAN. Mr. Etigwewa, SAN. Right Honorable Olumide Osyoba, Mrs. Letitia Ayola Daniels, the miracle worker of the committee. Mr. Adizo Okorafo, Mr. Felix Ota Okoji, Mr. Fernandez Marcos Obiane, Mr. Sunday Umeha, Mr. Jude Ezobi, Mr. Chidi Dingba, Mr. Rafael Agbai, Barrister Abdullahi Tafarki, Mrs. Medinet Akani, Ms. Josephine Laladi. I think since the beginning of this summit, she had been on her feet. I don't remember ever seeing her sitting down. Mr. Kamar, yes, thank you. Mr. Kamar Ogundele, Mr. Nelson Azuna, Miss Ayodeji Oni, Mr. Habib Lawal, who is also our co-MC, Adeze Opara, Miss Kemi Beatrice, and our able secretary, Mr. Osman Endoras Odushela. And of course, the support staff from the Federal Ministry of Justice and the Nigerian Bar Association. Your selfless service to the bar and the entire justice sector made this possible. I particularly wish to reiterate our appreciation to our chairman, Dr. Babatunde Ajibade SAN, for his public-spirited sacrifices. Not only was he shuttling between Abuja and Lagos at his own expense, but he did so with patience, understanding, and perseverance. We really appreciate you, sir. For our participants visiting for the first time and even returning visitors, I encourage you to use some part of your remaining time to enjoy the beauty and hospitality of Nigeria and Nigerians, and our committee members are available to provide information and serve as guide where required. The miracle worker is here. That is Mrs. Ayola Daniels. Finally, I would like to thank Almighty Allah for sparing our lives to witness this summit and for seeing us through to the end. The work has begun. It is our hope that by the time we reassemble again on this subject, we'll be taking stock of a very long list of achievements recorded. We thank all the members of the Nigerian Bar Association, each and every one of you, physical and virtual participants, for your active engagement, and wish the traveling participants safe return back to their various destinations. Thank you so very much. Thank you.
Please, another round of applause for Dr. Balake Saidu. And most importantly, a round of applause to all the participants. You have all been incredible, and I am certain, before we started, I didn't have this kind of certainty, but I'm assured that with the kind of conversation that has gone down in this hall, that Nigerian judiciary is definitely poised to be repositioned for the common man. Thank you so, so much. Thank you, everyone. Now, we'll be having a group picture just outside the hall here, and I encourage everyone to please come around for that group picture to save some memories from this wonderful summit. Thank you so much, and safe journey to your various destinations. God bless you. Behind here, please. Yes, by the staircase, just outside this hall. Huh? Who's Andrew? Thank you so much. Just outside the hall by the staircase, we'll be having a group photograph with everybody in this hall. Everyone, please. Thank you so, so much for your time.